fingerprints. After the vaporized gold is applied to the bag, it's followed by zinc, which the zinc gets vaporized, and that zinc kind of, for lack of better words, seals that print in place. On this particular bag, the results were negative. However, I believe something was found in it of value, and the Miramar Police Department does not have the capability to, they don't have that machine. So I wanted the evidence to try to attempt to make fingerprints out of it.
In terms of the casing that was recovered, did you do additional analysis on that?
Yes. So we also have what's called a Recover LFT system. That system essentially is another vacuum system where we place a proprietary sulfur mixture into a chamber. We put the fired cartridge case into the chamber, and the theory behind that is, so your skin has the lipids, but it also has oils and water. But the oils, they begin to etch metal the second that you touch it. And that metal will continue to be etched by that print until that cartridge is fired. So when you load...
If I can interrupt you, is that assuming that there's a good print on the casing?
That's where I was going, yes.
Okay,
So when you load a magazine, you're going to load it with your thumb or your finger, and you're going to enter cartridges into there. And you're going to handle that. You're going to handle that cartridge. So your print is going to be on it, and it will continue to etch. And it's etched until fired. So I took the cartridge case, I signed it out from the Miramar Police Department, I put it into there, and that proprietary sulfur that the company, Foster Freeman, who makes the Recover LFT system, they're able to extract the etching of the fingerprint from metal. On this case, a fingerprint was developed. However, it was determined by our lab analysis of the link print unit to be of no value.
and so in terms of the further analysis on that item, did you do anything else?
On the cartridge
On
case?
the cartridge case?
No.
And when you're processing it with the sulfur, does that change the color of the cartridge casing?
It adds a blackening to it.
So I want to go, and we've talked about the injuries to Anthony Williams, so I want to go now on to Christopher Thomas. With regards to inside the car, can you discuss the injuries to Christopher Thomas's head and what you observed based on your training and experience?
So Christopher Thomas had an injury to his left cheek. Part of that injury, his face or his cheek, if you will, had the tattooing or the stippling on there, which is indicative of close range fire. Also, part of the wound had an abrasion ring on it, which is also indicative of close round fire.
So I want to, with a demonstrative of the head showing the entrance would help in explaining your testimony.
Yes.
So I'm showing counsel what was previously shown to Dr. Sauter and then identifying as EMEO 18-3119. And the mark on here placed by Dr. Sauter.
Again, ladies and gentlemen, the witness is using a demonstrative to assist in explaining or illustrating his testimony. Remember that the evidence is the testimony of the witness, not the demonstrative exhibit unless it's later received in evidence only. Items of evidence will go back with you to the jury room during your deliberation, so it's not accepted into evidence at a later time. It doesn't go back to the jury room.
So, Sergeant Williams, with regards to Christopher Thomas, did that projectile exit his head?
No.
So can you give the same type of opinion as to the orientation of Mr. Thomas's head that you did as to Mr. Williams?
I can give an orientation that he was facing forward.
And how can you say that?
Because the projectile that entered into Christopher Thomas, that's actually about in the middle of his cheek, was completely, it was a full circle. There was no leading edge. There was nothing to indicate that his head was turned to the right, turned to the left. It was straight forward, looking forward. It was the circular pattern that indicates that he was facing forward when that round entered his cheek.
So, Sergeant Williams, you talked about directionality on the car. Does the same thing apply on skin?
Yes.
So you mentioned earlier doing a height and measurements on 2 individuals. What 2 individuals did you measure in this case?
I measured Jamell and Cortland Henry.
You discussed about an angle at 90 degrees. Can you exclude or include someone just based on that particular data?
I'm directly 90
Correct.
with no other measurements?
Yeah. Yes. Can you do that?
No.
Why not?
Because you're right at 90, and 90 is that it makes the exact right angle. It makes the perfect square, and you get nothing. You're back at 0.
Can a person hold a firearm in a way that is different than 90 degrees?
Yes.
How many different ways have you seen videos during your time in crime scene of people holding firearms?
Many firearms are held in all different ways.
So when you're talking about the shooting reconstruction and ranges, what are the limitations on that particular information that you would give to the jury?
The limitations would be environment, gun, ammunition, any intermediate targets. Those would all be limitations.
Is there anything that requires an individual's arm to be fully straight out before they fire a firearm?
No, you don't have to have an arm fully extended to fire a gun.
And so, Sergeant, with regards to firearms, how long have you carried a firearm?
For almost 20 years.
And are you required to shoot that firearm on a regular basis as part of your employment at the Sheriff's Office?
Yes.
How often?
We shoot about 3 times a year.
Okay. And is there anything about the location or positioning of an arm that you take into account on the ability to pull a trigger?
You can pull a trigger with either hand.
So going forward on Chris Thomas inside the car, you said that you can give a distance away based on the measurements inside the car. I'm going to talk a little bit more about that now. How can you determine that that door is closed?
The door, which door?
The rear driver's side passenger door.
That door was closed because I actually applied a chemical called Blue Star to it. Blue Star is attracted to the hemoglobin blood, and it reacted positive, which would be indicative of the door being closed. It actually captured some of the blowback from Anthony Williams and struck that door.
Can you describe to ladies and gentlemen of the jury what types of alternative light sources you used when processing this Jeep?
So I used UV lighting, and the UV lighting is used to locate potential gunshot residue. We're looking at it really illuminates like the barium and the nitrates and gunshot residue. It's also followed by wearing orange goggles, and it allows me to find potential gunshot residue, and then on top of it collect the gunshot residue with a special dauber, which is part of a gunshot residue kit, and it's sticky, so I would come by and dab, if you will, the GSR, the gunshot residue that is identified by the UV light and the orange goggles.
So the image that we're looking at here, which is identified as CSW_4814, what are we looking at here?
So this is the driver's side back passenger seat compartment area with that door open, with the passenger door in the open position.
And why is it kind of orange?
It's orange because as I'm also wearing orange goggles, so there's an orange tint lens on my camera.
And what are you showing with these particular images?
So I'm showing potential GSR, which is, do we have a different color? That's not good. Here is potential GS. There's one right here. Potential GSR. So these are here, all collected with the dauber.
Okay. And those were submitted to RJ Lee for analysis?
Yes.
Going on to this back seat here, what are we looking at in this photo?
This is the driver's side of the vehicle, the back seat, and there's potential GSR on the back seat. There's some right here, and right here. Nope, I'm sorry, that's not GSR. These areas here were GSR that were collected.
And so it's clear for the record that the two that you're circling on the right.
Yes, I'll redo it. Those two right there.
Okay. In terms of this photograph, what are we looking at here?
Do we have a prior?
Is this the back of one of the seats?
Action, lady.
Sustained.
What are we looking at in this photo?
This, I don't know which seat this is. I think it's the middle seat, but I'm not sure.
Okay, well, I don't want you to guess, so we'll stop on that. Okay, going forward to this photograph, can you orient the ladies and gentlemen of the jury as to what this particular part of the car is?
This is the back seat, and this is the center console that flips down, that has cup holders in it so that you can place drinks.
Okay. And did you see any suspect GSR particles in this area?
Yes, so there's some, there's some right here and right here that were identified on dab.
Okay. With the orange tint on it, is that some of the things you're talking about, the difficulties of forensic photography?
Yes. So this is actually the top of that center console where it's the storage area for it. So if you wanted to flip it up, it has a place to be. And this is actually some GSR right here, that would be from the ejection port of the firearm, and this is some GSR over here as well, and that was collected on the dauber.
Okay. Now looking at this next photograph, what are we looking at here?
This is the front passenger seat of the rear of it, and it identifies GSR as well. There's some right here, here, and here, which is indicative. There's actually one right here. That's indicative of that intermediate object intercepting the majority of that gunshot residue.
Okay, and in terms of that item, I'm going to make sure I show you and identify it for, it's been previously admitted into evidence as state 60.
Uh-oh! Shut up!
State 60. Okay, so Sergeant, in terms of the item here that's been previously admitted as state 60, is that the dauber that you're talking about?
Yes.
And can you explain exactly how it works and how you collected it?
May I show it to the jury?
If it helps, we can publish it on the large screen here. You just have to step down.
So this is a collection vial, and on this brown part here pulls out, and on the bottom of it is a black sticky item. And I'll explain its purpose besides collecting in a second, but I want to show what that bottom looks like. So when this is sent to a laboratory for gunshot residue analysis, this is actually what's called a SEM, S-E-M, and they put it into a mass spectrometer to determine the gunshot particles that are the gunshot residue particles that would be there.
And is this the SEM that you use to collect the GSR suspect particles?
Yes.
Okay, so Sergeant, I'm going to show you what's been previously marked as state GG and shown to defense counsel for identification. So Sergeant, I'm showing you it states GG for identification purposes only. Do you recognize two out of those three items?
Yes.
How do you recognize those two items?
Those are my signatures and my ID on those.
And are those items in the same or substantially same condition as when you collected them?
Yes.
Your Honor, at this time, the state would now admit states GG into evidence.
No
Any
good.
objection?
And so,
I'm sorry, I didn't hear. Is there any objection?
No, sir.
It'll be admitted.
States GG will be marked states 80.
yes, 80. Okay, Sergeant Williams, with regards to the items in this particular packaging, what are the 2 swabs that you collected?
So on the back of the driver's seat of the vehicle, I observed when I applied Blue Star, the chemical that I spoke of that illuminates blood and the hemogroup of blood, I observed what appeared to be a swipe in blood. And a swipe is a blood-bearing surface being transferred to a non-blood-bearing surface. So in this case, a finger or a hand transferring to the back of the seat, which had no blood on it. And I observed this swipe. So I collected with a swab the swipe, and then I used an additional swab to collect the non-blood areas on each side of the swipe.
Okay. So in terms of the location, is there a photo that would help demonstrate where that came from?
I believe there should be one in here.
Excuse me, can we approach first?
Yes?
Maybe it'd be a good time for lunch.
Sure, so.
So, Sergeant Williams, we were on the discussion of the DNA swabs that you had collected. Is this a good photo for you to show and demonstrate the blood smear swab as well as the non-blood smear swab?
There was one that was with Blue Star, but I can point in the general area where it was.
Yes, just for
Okay,
this
so
purposes.
the general area of the swipe was here,
Okay.
and that was a swab, and then I conducted another swab of a non-blood area and a non-blood area.
So Sergeant Williams, I want to ask, did you collect any swabs from the door handle of this Jeep?
I did not.
When were those swabs collected, if you know?
Those were collected by the Miramar Police Department during their initial investigation.
So council had asked for lunch break. This would be a logical point to stop at.
All right, ladies and gentlemen, we'll take a short, take a recess for lunch. Remember the admonition, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence, certainly no research. Just leave your notepads on your chairs. We'll see everybody back at 1:15. All right? Thank you. Have a nice lunch. Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant. Anything to discuss?
No.
All right. See everybody back 1:15. Thank you. Have a nice lunch.
We got an hour. What y'all think, man? I've been on the phone emailing back and forth with this company. Don't you hate when these companies owe you money and they just hate to admit they fault? Like, I can't stand it. Make sure y'all hit that subscription button. Appreciate y'all hanging out. We had some technical difficulties earlier, so I had to restart. I appreciate y'all that came back. Hit that thumbs up for your boy. It's been a great last 2 weeks back on YouTube. Honestly, I can't wait till this trial is over. But since I started it, I gotta finish it. But we do get a little break from the 3rd of July to the 10th.
It is a very
I guess they're gonna
strong variable. Semi-automatic firearms have springs.
I want to speak on it. So yesterday. Let's go back to yesterday. Yesterday, you had the chief medical examiner and another medical examiner that worked under her, both of whom testified. Both were in charge of doing the autopsy on one of the victims, of the 2 victims. Each medical examiner took one of the victims and they did the autopsies. On both victims, they received a fatal shot of, what'd she say? Intermediate. I think that's the word from yesterday. Intermediate was the word of the day yesterday. Intermediate range. With the latter medical examiner, I think it was Dr. Saunders, she stated that one of the victims had a wound to the cheek area, and the wound had stippling, which only occurs in wounds, gunshot wounds of a distance of 3 inches up to 36 inches. So 3 inches up to 3 feet. That was her testimony. Now, why this is important is defense claims Melly says that this happened in a drive-by shooting. Well, if they're close range wounds, then that kind of refutes his story of it being a drive-by shooting. So you fast forward to today, and now you have a expert at Reconstruction of gunshot scenes or what have you, and he states that a lot of the defects from the projectiles that he traced with rods, which he demonstrated, shows that the shot came from the back seat. At least on one of the victims. Shot came from the back seat. I just don't see how anybody in a right mind. Of course, the defense are going to put on some experts that are going to say, well, it could have been this, it could have been that. Again, let's go back to the original reason that this was even investigated or Melly was even considered a suspect. Because at the time of the incident, they claimed it was a drive-by. Detectives did their investigation and surmised that these shots could not have come from a moving vehicle. Later on, the medical examiner says that these wounds could not have come from a moving vehicle because they are close encounter wounds, intermediate range wounds. So, with that being said, why do you even have to put a gun in his hand? Why do you have to even, go that route of, well, look, I said this before, if it was a domestic situation and the husband did something to the wife or vice versa, and he says he was somewhere and it's proven he wasn't there, or it's proven he didn't take the path that he said to get there, then he's automatically going to become a suspect because his alibi or lack thereof makes him a suspect. So I just, again, I don't want to see the young man get capital punishment. However, I also don't want somebody that could do something as heinous as this to walk free. Because it could be your child, it could be, your mate, your mama, your daddy that is the victim. And then I think you would feel a lot different. So all these people putting in the comments, he's not guilty, he's not guilty. Okay, that's fine. That's still yet to be determined. But how you argue this evidence down, I don't see. I really don't see. You got a lot of people saying, oh, he didn't have gunshot residue on himself or his clothing. Well, according to the state, if you go by their theory, if you're driving around with the victims in the car and you calling Frito Bang for rides to get picked up right after the crime in question took place, you hitting Frito Bang up, trying to get him, you dropping your location. You dropping your location. Come pick me up. Why would you want to? You didn't say come pick me up from the hospital. You didn't drop your location from the hospital. So like all y'all that want to play ignorant, and you know what? I don't even get these legal experts. I feel like they into this to pump up the views. Because if they get on here and say, oh yeah, half the people gonna stop watching. The numbers already went down. It was 90,000 people watching on Law and Crime. Shout out to Law and Crime. It's about 30,000 people now. Because I think a lot of people say, man, this is long and drawn out, and they kind of made up their mind. Well, they would have made up their mind the first day if a lot of these pundits, legal experts, lawyers, prosecutors, former judges that they have on the show would say, oh, well, it's kind of hard to dispute this, that, and the third. It's looking bad. No. They're going to keep egging you on to bring you back. How do you explain that? The evidence that they do have does not necessarily point towards his guilt. However, it refutes his alibi or story that he gave as to how it happened. Now, that's the bottom line. You can say anything else that you want, but the witnesses between yesterday and today have all pretty much put the state's case on that he wasn't outside of the car. And then you throw in the fact, and I'm just going to tell you what we're going to hear on closing arguments, because I've already pictured it in my head. Did what he did, or Bortland did what he did, because it's not clear as to who exactly did it. One of the two did it, right? To me, it's common sense. And without saying Bortland did it, the defense is using that as well as a tactic. Well, it wasn't Melly. It could have been but if it wasn't Melly and it was Bortland, then Melly still lied. Maybe he didn't want to be labeled as a snitch because he is a gangster rapper of some degree, I guess. But if Melly didn't do it, and it happened in the car, then there was only one other person, that surviving person, that was in that car. You know what I mean? So he calls his mom. Oh, let's not forget that. I don't know if he called. Yeah, he called his mom. He called his girlfriend too. That's why she's missing. And then he calls his mom to get another gun. And what the state is saying, he called to get that gun to stage the drive-by. Which, if he was smart, I'm going to just keep it real, you should have gotten a car and had somebody bring you in a car and maybe shot at the car from a moving car. But who says criminals are always the smartest individuals?
Medical examiners testified that she had gone and viewed the car and sort of matched up the trajectory and those
Let's
rods,
keep it a buck,
those trajectory
man.
rods
Buck
with the
on
actual
Dopest
bullet
TV.
Entry wounds. What is the significance
Shout
of
out to my
the
people, man. Hit that
testimony we see
subscription
now
button.
for the
Notifications,
prosecution, given that this is a circumstantial case relying heavily on forensics?
They are definitely relying heavily on the forensics here. But this witness is such a great witness for the prosecution. I mean, he is doing such a great job at laying out the trajectory of the bullet wounds and of the gunshots as they happened. I'm pretty much convinced that the initial gunshot came from within the vehicle. And then that there were gunshots that came outside of the vehicle from a stationary person. So he's doing a great job there. I would say that I'm looking forward to seeing how the defense handles it and what they do to kind of poke holes in his testimony and to question him and to see exactly what it is that they will come up with on their cross-examination here, though.
Yeah. And Brian, let's talk about that. The defense, they're sitting there, they're gearing up for cross-examination. They're analyzing this evidence as it's being presented in court and this expert's testimony. What do you think their best line of questioning is, given the fact that their theory is that these bullets came outside of the car in terms of a drive-by shooting, yet this is sort of establishing, at least for the prosecution, that these may have been actually internal within that car, those shots being fired?
For lack of a better phrase, I think the theme should be check the math. The way I analogize it to is long division. You look at what number is going into what number and then the answer, and you're like, as a defense attorney, I'm not sure if I can argue the number, but let me check your math. Okay, did you carry the one here? Did you divide here correctly? Did you subtract here correctly? And if the defense can do that, they might not even have to say that the bullets came from outside. Simply moving it from the back passenger seat, so the seat directly behind the driver, and moving it maybe to the center, or maybe moving it to behind the passenger, or even moving it to the passenger. Maybe even move it to the driver. If you can move it anywhere from that one seat, because the math was just a little off, you might be able to create more reasonable doubt and destroy the prosecution's case.
Yeah, no, I 100% agree, in terms of attacking an expert's methodology on how they came to a conclusion and their opinion is really just as effective, if not more effective, than attacking the conclusion itself. Because if the method in which they got to that point is flawed and you're able to raise some reasonable doubt with that, then you may be able to do away with that expert testimony altogether. We're going to take a quick break here at Law and Crime. When we come back, we're going to do our Q&A session with you, the viewers. Stay tuned.
Shout out to Law and Crime, man. They doing a great job of coverage of this trial. I gotta say that. They waiting on the verdict over there in the Scott Peterson trial. Moments ago, I got a message that Ocean's Gate Titan, they brought up the first pieces that they recovered from the bottom of the Atlantic Ocean. I still can't believe people starting to talk about the Greek ship. And the 700 plus people that were on board that, they said that's one of the Mediterranean's, in recent history. I'm sure way back when something may have happened, but in recent history, that's like one of the worst maritime ship disasters. Yeah, I can't think of nothing that come close to that. Over 500 people lost their lives in the ocean that day. So, crazy. I know these people gonna pay me my money. Hold on, let me see. So, okay, back to the trial. So, okay, where we left off at the trajectory expert or recreation guy, and I just don't see as many people are hooping and hollering about he's not guilty. I don't see how they gonna bring another expert in here and they gonna make these holes line up different. How do you do that? Somebody tell me. How you gonna make the holes line up different? Now, we remember back when, and we always reference OJ, and it don't matter what kind of case it is, right? But especially a homicide case. Remember OJ sticking the gloves on? And he was like, oh, they don't fit. And then after the trial, everybody was like, well, he had on another pair of gloves and tried to put them on top of the gloves. And then you could make your hand. He was slick with it. He was slick with it. All the evidence was contaminated. But in this case, I think the weapon used in the Nicole Simpson and Ron Brown, is his name, situation was a knife of some sort, right? Well, this is gunshots. One thing about gunshots, they're going to go in a straight line till they bounce off something. After they bounce off of that, it's going to go in a straight line till it bounce off of something else. Am I right or am I wrong? Because unless, what movie is that? Wanted or something with Angelina Jolie? Where they take the gun and then they go like that and then whip the bullets around the corner. That don't happen, y'all, in real life. That don't happen in real life. I hate to burst y'all bubble, but that don't happen in real life, man. I think a lot of people need to come to grips that their worst fear is realized, because I'm sure, I know he has a lot of like real fans. Not all these trolls that we see that's on the internet talking about not guilty. I'm not talking about them. I'm talking about real fans. But I ain't gonna lie, y'all. I don't know how the defense is.
To our YNW Melly Q&A.
I don't know how the defense is gonna make these holes not match up. Like, somebody tell me in the comments, in the chat, whatever, How you think the defense can make these holes not match up? It's science, man. Rest in peace.
Recording
Zach
studio in
Jason
the early
Jr.
morning hours of October 26, 2018, when the incident occurred. Henry and Devins claim that they were part of a drive-by shooting, but the authorities disagree. For the next hour, I will be taking your questions with my expert legal panel. I'm Imran Ansari, filling in for Anjanette Levy. So let's get to your questions right now. Okay, first question, at 205 Serial Killer, and that's with a C, not an S, from YouTube, has a question for Terry Austin. Do you think the jury will question the credibility of these experts on the stand today? Terry.
Well, I think, yes. I think when we see the cross-examination, the jury will be questioning whether or not this witness, and who's on the stand right now is Sergeant Christopher Williams. He is the crime scene analyst. He's the investigator who looked at this crime scene. He said he found 2 bullets in the car, or 2 projectiles in the car, one under the back seat, one in the B pillar, which covers the seat belt. And he's basically confirming what the medical examiners said yesterday as far as the injuries of Anthony Williams and Christopher Thomas. I think when you see the cross-examination, you're going to see that they are questioning, and that's going to come later, they're going to be questioning, well, did you for a fact know what the distance was? Because again, we don't know the exact height, we don't know the exact distance, and they're going to be questioning those projectiles. And as a matter of fact, the prosecutor even said these aren't going to be exact distances. So she's trying to take some of the edge off of that testimony when it comes in our cross-examination. But I think to answer the question, basically, yes, the jury is listening. They are thinking right now, probably he knows what he's talking about, but based on cross-examination that I've seen in the past, I think they're going to be questioning, maybe there are some issues that aren't 100% resolved here.
Absolutely, and that is Terry Austin reporting right there in the courthouse, really getting a first-hand view of everything there. And then Terry, I'm sure you're going to be reporting back as to how that cross-examination goes, and we'll be watching that. Also here with me is Law and Crime Zone, also Brian Buckmeyer. And Brian, I'm going to throw this question to you. It's from Dominique Thomas from Facebook, and she asks, is it possible that the car was in a drive-by and the shooter got in the car and shot the other 2 victims? The projectiles just don't seem accurate. What do you think?
So is it possible that it was a drive-by where the shooter was inside? It could be. I mean, it wouldn't be the technical definition of a drive-by. So I think the question would be, why did you describe it like that? Why didn't you just say that someone broke into the car and shot? But it would create a good explanation for the defense as to the shooter being someone else. I've also seen people make a similar argument, Dominique, that I do think it works at. What's to say that someone didn't stop the car, lean in, and shoot at everyone inside the car? That could kind of be like a drive-by, and that could explain that someone else, rather than YNW Melly, did the shooting. The question is, while it's doubt, is it reasonable doubt?
No, absolutely. And I think that sort of forensic evidence regarding where those shots came from is going to be all so important when the prosecution is trying to prove their case beyond a reasonable doubt. Let's go to our next question. I'm going to throw that to you. Bridget Williams, criminal defense attorney in Dallas, Texas. We have a question from @FeistyGemini2379 from YouTube. And the question is, where exactly is the evidence in this trial? There doesn't seem to be anything that definitively points to him as guilty, which I thought there would be for a death sentence as a punishment option. Defense attorney Bridget Williams, what is your take on the evidence in that question?
Well, there has been some evidence that has been presented by the state here. Is it a definite, is it a slam dunk? Probably not, in my opinion. We're still looking to that. The state isn't over yet. They are still presenting their case. And when we talk about something where the state is seeking the death penalty, it's past just if there was a murder that was committed, then we go on to the aggravated factors that are here. And those aggravated factors that the state is pushing for is, was it a heinous crime? Was it premeditated, and that he was a part of a criminal gang association? And they had some testimony about that previously with the gang expert that came in and testified. And then they also are talking about, you know, those other aggravating factors. So when we talk about, are they seeking the death penalty, they are going over it with those aggravating circumstances. They have presented some evidence, but so far, I don't see a shooting gun that says that it was in fact Melly that committed this offense, though.
Right. Next question is for our boots on the ground reporter, Terry Austin. Terry, Christy Smith from Twitter asks, why didn't he have GSR, gunshot residue, but the co-defendant did? Could they have been shot after he got out of the vehicle?
Well, I tell you, I can guarantee you that's something they're going to focus on during closing as far as the defense is concerned, because Melly did not have GSR on him and Henry did. And I think the argument will be, look, he wasn't there. He wasn't in the car. He might have gotten in the car. And don't forget, we have the video where he's getting into the car. He's getting into the back seat of that car on the driver's side. And that's where they're saying those bullets came from based on the trajectory of those bullets. But I think the issue here is if there's very little DNA of Melly, if there's no GSR, if they don't have the gun, and if they can't prove who was sitting back there and making those gunshots, which they say are the shots that killed the two victims and not the drive-by shots, I think it's going to be very difficult. I think there will be reasonable doubt. And I think it's a very good question because there was no GSR found on Melly anywhere.
Great. Thank you, Terry. And a very good answer from you, Terry. We're going to take a quick break here at Law and Crime, but keep those questions coming. We're going to be back with more Q&A on the YNW Melly trial out of Florida. Stay tuned.
All right, y'all. I'm over here having my own sidebar with Big Stepper, aka Dopest Boo Boo, and my Lotus Flower. We talking about back surgeries and all kind of other stuff. Because this is over. This is a wrap. Man, put a bow on it. Put a bow on it. I'm going to tell you right now. At best, it's going to be a hung jury. And when I say at best, I mean at best for the defense. Because I do not see a not guilty. I just don't. I just don't. Now, again, it does matter heavily the makeup of the jury. You know. But I don't see it. I don't see it. If you'd asked me 3 days ago, I said, man, it's a good chance that, you know, he might can skate. But I said from day one, the medical examiner and this type of evidence was going to be like my holy grail. That's what I'm holding on to. Like, real talk. Real talk. Because you can't explain away that. If here's the other thing. Now, if the car was parked and there's another car coming behind him and a dude hanging out the window and he's shooting from the back, yeah, it could be something that some shots that look like maybe they came from the back seat. I give you that. And I was thinking about that may be an angle the defense runs with. But the ones on the side of the car, because you got to remember, if you driving, the angle of the projectiles going into the car are going to be kind of like from they're going to be from an angle. They're not going to be direct, straight on. Like, what? See, That's what people don't want to hear is the science. How a hole looks when you just standing in front of it shooting. You know what I mean? As opposed to how a hole looks when you driving by shooting. And these are people, this is Florida, y'all. Florida up there in homicide rate. So I'm sure that they've had plenty of cases and crime scenes to investigate, to where this is a science studied around the world, forensic science. Forget who said what, when, and where. If they can't figure out how to make these holes not look like it came from inside the car, how could you not find him guilty? Now, maybe you might not give him the capital punishment, because at worst, he lied. No. At best, he lied. Let me take that back. At best, he lied. He knows what happened and lied. At worst, he's the actual perpetrator. Either way, you got to think, if he didn't do it, why wouldn't he get told? Not being labeled as He's already
okay, welcome back to Long Time, where we're covering the YNW Melly trial out of Florida. And court is on a lunch break right now. That gives us the opportunity to interact with you, the viewers, and take your Q&A or your questions and give you the answers. And I have a great panel with me. I have Terry Austin, who is actually at the courthouse down there in Florida right now. I have Bridget Williams. She's a criminal defense attorney out of Dallas, Texas. And of course, Brian Buckmeyer is here with me in the studio. Let's get back to your questions. And Brian, this one's for you. It's from Janina43, and she wants to know, how are there still any doubts that the victims were shot from inside the Jeep? There were a lot of shell casings found inside the car, as the pictures showed.
Janina43, thank you for that answer, or for that question, sorry. I don't think there's any doubt. I think at this point, especially we know from the prosecution, this witness is going to be on the stand for 2 days. It's not just beating a dead horse. I think the horse at this point is glue. But of course, I understand the defense is going to make a lot of noise and it could have come from the outside, so cover all your bases. But I think you've done it enough here. I think the better thing for the prosecutor now is to move on and put the gun in YNW Melly's hand. We know where it came from, the shooting, inside, not out. We know that Cortland Henry lied based on the forensics. Move on and tell us something greater. Otherwise, it makes it seem like you can't prove that bigger question and you're focusing on these smaller ones a little too much.
Right, so the prosecution needs to take that glue, put us all together for a neat package with the jury at the end of the day. Next question for you, Bridget Williams. I'm going to send you this one. It's from @MandyMartis402 from YouTube. And she asks, why did none of the experts test for stippling on the victims? That was very important. And the defense team was asking a lot of questions about Melly's text from that phone yesterday. Wasn't that them accepting that it was actually Melly's phone when they have been trying to deny it up until this point?
Okay, well, thank you so much for that question. I'll start with, I guess, the text messages. The text messages that the defense counsel was going over yesterday, he was talking about the connection that Melly may or may not have had with gang affiliation. So he was explaining there, or trying to cover that Melly was somewhat being recruited to be affiliated with the gang there, and that he wasn't necessarily a part of it. And so he continued to ask questions to the gang expert to see if, that showed that he was not in fact a part of the gang, but that he was being recruited about it. There were several text messages that the person that was involved in the gang was continuing to ask Melly over and over again. He had no response. I think there was even some testimony that said that some of the text messages asked Melly to post that person on his social media so Melly could look over some of his like records as well, like just communication with him. And so it didn't necessarily tie him to being a gang affiliated, but to show that he was being recruited to be in the gang. And then that alleviates that connection that the state is looking for criminal gang affiliation.
Right. Let's move on to Terry Austin, who is reporting from inside the Broward County courtroom or courthouse. Terry, Styles1211 from Instagram. The question is for you, if they don't find him guilty of first-degree murder, can they find him guilty of a lesser charge?
Well, they haven't included any lesser included charges, but as the evidence presents itself, they can always amend the indictment and add those charges to be the lesser included. I don't think that's going to happen here, and the reason is they've asked for the death penalty, and I doubt very seriously if they will change, their direction and ask for a lesser included. Anything is possible, but all of the evidence the prosecution has put forth so far is pointing to this was, cold, calculated murder is what they're claiming. They're saying that it was heinous and atrocious, and they're saying that it's gang related. I think it's going to be very difficult to argue an alternate theory with that sort of charge that they've done so far. He has those 2 murder charges, and they're asking for that death penalty. So it's possible, and we've seen it in other cases. I don't think that'll happen here, but we'll wait till the end of all of the evidence, and maybe with the defense evidence, there will be something else that they can look at as far as those charges are concerned.
Absolutely. And Dariha from YouTube has a question specifically for you, Brian. The prosecutor said in the opening the victims died at the scene, but McDougal said the victims died at the hospital. Does that affect the credibility of the case at all?
Well, Dariha, first of all, eagle eye spot on that one. I missed that as well. I think it could affect the case, if at any, in terms of like one more piece, one more bit of sand on the pile of, does the prosecutor have the credibility in front of the jury that they want? Whenever you give an opening statement, whether you're a defense attorney, a prosecutor, and Imran, please jump in on this and tell me if you agree afterwards. I always say you want to underpromise and overperform. Because if you do it the other way around, viewers like you are going to do exactly this and say, wait a second, you said this, but it ended up being that. You also said this, and it ended up being that. And if it starts to get kind of like a waterfall of just more and more of that, then come summation time, the jury's going to say, you know what, either one, I don't believe the prosecutor, and I believe the defense more, and I'll go this way, or I don't believe any of you all. Give us all of the exhibits, all of the evidence, and we as a jury are going to figure this out because both of you don't know what you're figuring out. As a defense attorney, I get scared if that happens. I want to be the most reliable and credible person in the room, so I want to make sure that what I tell you in opening happens during the trial, and I remind you again in closing. So for even a little mistake like that, I do think so. It could have some effect.
Yeah, Brian, I absolutely agree with you, especially when you have reason to believe that maybe some of your evidence is not going to come in at trial. You never want to mention that. You never want to promise something you can't deliver, or the jury is going to suspect something about your case possibly. Bridget, I want to go to you for the next question. It's from @TTech from YouTube, who asks, why is the prosecution allowed to be admitting new reports that were reevaluated June this year? They've had 4 years to put the case together and only found all these issues recently. How's that fair to the defense?
Well, the state has the opportunity to continue to do research as they continue throughout their investigation. So they have the right to do that. The issue is, as long as they alert the defense counsel about it and defense counsel knows about it and it comes in before trial, then it's perfectly fine. And there was some issues prior during the trial where the prosecution tried to bring in some evidence that the defense stated that they had no idea about and that it was a matter of surprise. And when that did happen, the judge did the right thing here, and he just didn't allow that into evidence. So that did happen here. But as long as everyone is on the same page, the prosecution has brought up that evidence to defense counsel, they know about it, and everyone knows about what's going on, then it's perfectly fine.
Okay, and Terry Austin, I'm going to throw this last question before we take a break to you. It's from Chris Carney from YouTube. And Chris wants to know, if you were the defense team, what questions would you ask Sergeant Williams during cross-examination?
Well, I think what we're going to see from defense counsel is questioning about, was he there? He does not really know. These are guesstimates. They're talking about geometry and using the Pythagorean theory, and that's how he's calculating these projectiles and how the bullets were shot inside the car and how the bullets from outside the car were shot and he was standing still, whoever the shooter was. So I think all of that is going to be questioned, and he's going to have to explain, well, you know, you're right. I don't have the exact answer. He's already basically said he can't give specific distances and he can't give all of those estimates that are, you know, the estimates that we're all looking for. He can't give it exactly. And so I do think that that's something that we're going to see during the cross-examination of this sergeant. Now, he's been promoted. I think other than that, you know, he's educated. He has a great background. He's been on the force for a while. I do also think that the defense is going to ask about what do you think about the Miramar Police Department's investigation? Because there were a couple of times during the direct exam that he mentioned, the police did not look out in the area where I looked. I went back and I looked. And if you recall, we heard during the defense opening that the Miramar Police Department was criticized for not doing a thorough investigation. So I think I would ask about that as well. And he may actually be one of the people who said, you know, it was an atrocious investigation, but I would definitely question the shoddiness or the thoroughness of those investigations.
Yeah, we're going to be waiting to see that cross, but right now we're going to take a quick break. Keep those questions coming. On the other side of the break, we're going to be giving you some answers and taking more questions. Stay tuned here at Law and Crime.
All right, man, let me look around, see what's going on real quick. Let's see, This is what I was talking about earlier. That's crazy, huh? That's crazy that they got that from the bottom of the ocean. Like, what? Look how little that thing.
And what I'm not understanding, you know, the mother changed her story about the son.
Girl, you always looking for some kind of conspiracy. Like, what you think?
No, but she did. The first time she said her son didn't want to go. He was terrified. And now she's saying, did she come out and say that he was kind of excited to go, but he really didn't want to go? And she didn't want him to go.
Well, he went, and they got blown to smithereens. That's what happened with that. You see, they bringing up pieces of this this thing, but they ain't gonna be bringing no pieces, no people back. So, man, pray for their families, yo. Let me see. Who is this?
The water pressure down there is just too tight.
That's crazy when you just famous enough to where you can't go to lunch or none of that. Y'all go ahead and make me that famous, y'all. I ain't even gonna be able to go to Arby's or In-N-Out or none of that. They're gonna be pictures of me on TMZ.
What is In-N-Out?
What? Let me go. Girl, let me block you today. Blocked. What is In-N-Out? So, yeah, that's why you at where you at. Let me see. Sade Wagner Reese requests immediate monthly child support after Neo files motion to establish the. Oh, okay, you want to get a look at Neo? Neo, you want to get you a DNA? Okay. Well, when it come back, you owe. Oh. Right. Man, did you see that thing about Cardi B and Offset had put on a tweet? It said basically, I don't know if this should be for content. It was like accused her of cheating, so she went live and she was clowning the hell out of him. Let me see what Steve Harvey got to say. Namesake. Success doesn't come to those who wait. It comes to those who hustle. Nipsey. This is some real hood love. It's Jazzy J 2 times. Casanova. She said she gonna hold it down. She said she holding it down, y'all. She holding it down.
Okay, welcome back to Law and Crime, and this is our Q&A session. Court is on their lunch break at the YNW Melly trial. That gives us the opportunity to take your questions and answer them with our great legal panel. And I have one question coming in right now for you, Bridget Williams. It's from Musical Jujutsu from Instagram. And the question is, if it is shown that the shooting could have taken place in the car, why wasn't there gun residue on him? Would he have had the time to change in there on the way to the hospital if he may have had a spare change of clothes with him?
That's a great question. I would say, starting out, one, that the gun residue, the prosecution hasn't really talked a lot about the gun residue, if it was on Melly or not. And if I were the prosecutor, I would be talking about that more. I feel like they should be really discussing that more if they had evidence to show that. And so if they don't have evidence to show that there was gun residue on Melly, then that definitely puts a hole in their prosecution. Now, that gives the defense counsel some really good leeway there to talk about, well, the gun residue was not found on Melly, and that the state has not really brought that up or has discussed that. And so that's a really great point for the defense to talk about as they continue on and when their cross-examination happens, along with when they put their own expert witness up, if they choose to do that. And if they decide that they're going to put up any other witnesses, that's going to be a great point for the defense.
Absolutely. I think that's going to be one point of reasonable doubt that the defense is going to be looking to hit home with the jury. Brian Buckmeyer, next question is for you. It's from @JustBrit910 from Twitter. The question is, so let's say it was a staged drive-by. Couldn't Melly have been dropped off somewhere and Cortland did this? He could have plotted this with Juvie, and after Juvie shot Sack, Cortland turned on Juvie and shot him. And also, these seem to be the best 2 days for the prosecution.
So I'll work backwards. I agree with you. This seems to be a better day for the prosecution. The trajectory of where the bullets came from, narrowing it down to a specific seat that we know that YNW Melly, at least at one point when he entered the vehicle, was sitting. That's strong evidence for them. But I agree with you as to your first part of your question, because I'm thinking about the cell phone tracking, where the two cell phones were together, traveling, then at some point they're separate. But they don't really have a timeline of what's going on when they're separate. So yeah, maybe YNW Melly leaves the vehicle and then the shooting happens afterwards. If I'm a defense attorney, I'm gonna tie that into the fact that no GSR, no gunshot residue was on Melly at the time. Because if you shoot a gun, the GSR ends up on you because of your hand and whatnot. But if you shoot a gun in a small confined area, GSR is on everyone. And so if there's none on Melly, maybe yes, he did get out of the car before this all went down. And maybe yes, he doesn't know exactly what's going on. So I think great question, absolutely a possibility. Again, is it doubt? Yes. Is it reasonable? It's up for the 12 people to decide.
Right. I think the defense is going to be going for a death of 1,000 cuts of reasonable doubt against this prosecution case, and that could be another cut right there. So next question for you, Terry. It's from Paragon from YouTube. The question is, why isn't the prosecutor not trying to show how Bortland isn't the shooter? I feel that this would give the jury more information on why this point towards Melly.
Well, I think the prosecution has to go with the evidence, and the evidence that they have so far, the best evidence they have so far, is from those two medical examiners and right now Sergeant Christopher Williams on the stand. And that evidence is showing that the bullets were shot from the back seat and into Anthony Williams and from the back seat into Christopher Thomas. And so they know for a fact when the people got into the car, they're saying Melly got into the back seat. So to say that the driver, Henry, was the one who did the shooting, I think would be antithetical to the evidence that they have. So the prosecution always has to go by that evidence. And right now, the evidence is pointing to someone who's sitting in the back seat. What they still have to do, and they haven't done yet, is to say that it was Melly in that car. Like Brian just mentioned, you know, he could have gotten out of the car and someone else could have been sitting back there and doing the shooting. We actually don't have a gun in Melly's hand doing that shooting yet.
Yeah, and we spoke about this a little yesterday, this next question. And Bridget, I want to get your take on it. It's from K-Bands from YouTube. And K-Bands asked, regardless of the outcome of both trials, what's the chance a RICO happens? It seems like the state could have enough evidence for that.
Well, you know, we don't know. The state may have an opportunity to do that. We just have to see how it goes. The state here has really focused their attention on Melly in this case. I'm interested to see how this continues to play out in Melly's case, and then when they again retry this case really with Henry, and see how that plays out first, and then we'll see if they even decide that they're going to move forward with a RICO type of situation. But right now, it's just the focus is on this particular trial. Is Melly convicted of the murder case, and then if so, do they have enough evidence to move forward with the death penalty or not?
Right. And Brian, next question for you is from Gavin Carey from YouTube, who asked, do you think that Melly will have the death penalty thrown out based on expert witnesses' testimony? It did not prove gang affiliation, more of association.
Yeah, I think yes, but so one, thank you for that question. Two, I think you're spot on. I think the idea of association rather than affiliation is smart. I would also ratchet it one more up. That's the First Amendment. You have the right to associate. It's not illegal to be a part of organizations or groups. That's why it's not illegal to be a part of like the KKK. It's not illegal to be a part of gangs. It's what you do within those groups that can be illegal. And so I think you're 100% right there. You're probably a future lawyer in the making. But I think that's almost putting the cart before the horse, because I'm not quite sure they can get a conviction yet. They've got to get the conviction before we have this conversation, but I think you're looking far ahead, and I think you are right in your analysis.
Right, and let's go to Bridget for the next question. It is from, actually this one's for you, Terry. Sorry, Bridget. It's from See Through You from YouTube, who wants to know, do you think the prosecution chose to prosecute Melly first to scare Cortland Henry into turning for the state?
Whoa, that's a great question. Oftentimes when you do have two co-defendants, one could turn on the other. Originally, this case was together. We had Henry and Melly who were being tried together, but it was severed. And so now Henry will come after Melly. And I do think there is some finger pointing already in this case. We have seen reference by defense counsel to the fact that it was Henry who went into that hospital and who basically initially lied to the police officers that he spoke to. It wasn't Melly who told, a lie. So he is essentially saying, don't forget, look at Henry, there's someone else too. Now, they haven't come right out and pointed the finger, and there hasn't been any evidence of them pointing the finger, but he did mention that during the opening statement. I think Henry will get the benefit of this trial to see what happens here. Obviously, if there's an acquittal, I think fingers will be pointing to Henry, and the prosecution will probably use that to go after Henry even further. I don't know what theory they're going to use if there's an acquittal here, but they'll somehow come up with a trajectory of the bullets that could have come from the front, or they'll have to change their tune at that point.
Right.
But definitely they can point together.
Thank you, Terry, and thank you for the questions there. We're going to be cutting out the Q&A right now, but thank you for your contributions. Stay tuned here at Law and Crime.
Not me. Yeah. Girl, I need to stop drinking coffee, period. We getting through this lunch break, y'all. I'm fired up. I got a little bit more energy today. So guess what? Y'all, you gonna see a new look on me here soon. Found out yesterday, y'all. I gotta wear glasses. Aww. Yeah, I know. Aww. Yeah. So, I'll be switching up the swag here in a minute. Make sure if y'all watching me on Super Live, y'all come on over to YouTube, man. Jump in the conversation. I appreciate y'all. We are watching and following the YNW Melly double murder trial. And if the information that was passed along to me is correct, we will soon be following the Nature Boy. What is it? A kidnapping? Somebody got to tell me. I can't remember. But we will be following that if it is streamed out of the ATL. If you don't know about him, check him out. Nature Boy. Just type it in the search and you'll see. He's accused of having a cult and the stuff that went on within the cult. He got, some of the girls jumped ship, had accusations, so forth and so on. Okay? So I'm going to be following that. This is the first trial that I have covered on my channel. It's fun. I'm already thinking ahead on little, different things that I want to do in the future in covering trials. But this one is hard, being that it's East Coast and it's starting at 9 a.m. Eastern. So, I got to be ready at 6. And I have been live every day at 6 my time. So, it's fun, though. You guys make it fun. I'm hearing some interesting perspectives on not just this case, on how people feel about law. So I'm enjoying it. We are at lunch intermission. I think we'll be back in the court in probably about 14 minutes, according to the judge, Judge Murphy. Let me see. What else? Free Melly. I got people in my chat. You guys might see a link pop up. That link is to Super Live. It's an app I stream on. If you're a serious streamer, it's a good way to make some little side money. So make sure y'all click that link, download that. Come holler at your boy. I'm King Dopus everywhere. So make sure you look up King Dopus on Super Live and let's get it popping. But as far as on YouTube, man, shout out to my man Denate McClendon for the super chat this morning, super chat donation. Also, shout out to my girl Royalty, also known Dopus Melanin from Dopusology. Thank you for your, consistent, continual support. Love ya. We back.
And welcome back to the Law and Crime Network. I'm Imran Ansari, and we continue to follow the trial of Jamell Demons, better known as YNW Melly. The South Florida rapper is on trial, accused of a double murder for the 2018 shooting deaths of Anthony Williams, also known as YNW Sack Chaser, and Christopher Thomas Jr., also known as YNW Juvie. All are part of the YNW collaborative, along with co-defendant Cortland Henry, who will be tried in a separate case. Now, today is day 10 of the trial, and we are hearing testimony from Sergeant Christopher Williams, a shooting reconstruction expert. While court is still on their lunch recess, let's recap key parts of his testimony from earlier today.
Do you recall at what point you were first contacted to assist in this case?
I believe it was November of 2020.
Okay. With regards to that, who contacted you?
You, ma'am.
Okay. What were you asked to look at and analyze in this case?
I was asked to determine if this shooting incident was a drive-by shooting.
So, if there was any other forensic testing that could be done, would you suggest that as well?
Yes.
Did you do that in this case?
Yes.
If you could just briefly, were you asked to consult at all with regards to cell phones?
No.
Any sort of location data or anything with regards to the location of an individual?
Location data, no.
Okay.
Location of an individual, yes.
And that's within the car?
Correct.
Okay, so let's talk a little bit about the physical evidence that you reviewed. Did you review the car in question in this case?
Yes.
Where was that car being held and stored?
That car was being held at the Broward Sheriff's Office confiscation warehouse.
In terms of in this warehouse, are the cars sealed individually in each location?
Yes.
What types of materials are used to prevent cross-contamination from the various cars?
All of the cars are closed. They are sealed with red evidence tape. If windows are missing, plastic goes over them so that nothing can get into the car. The plastic would assume the role of windows so that nothing can get inside.
Okay. In terms of the security of that building, is anyone allowed to come and go into that building?
Absolutely not.
When you are doing an analysis of this Jeep, this car in this case, how do you do that?
So in this case, I actually had that the vehicle in question towed from the confiscation warehouse to the crime scene unit, which has a forensic processing garage. And from there, I began my investigation on the vehicle.
In terms of the image that we're looking at here, can you show the ladies and gentlemen of the jury where that blowback pattern was?
It would be in... Is there a way to make it circle?
Would you like to draw?
Yes.
Okay.
It would be in this area right in here. It's a little bigger than I drew, but it's in this general area right here.
Okay. In terms of the information about that DNA, why is it important to know whose DNA that is?
Well, it's unusual to have the blowback on the headliner, so of course, and for this shooting incident, we would want to identify where that blood came from. So that's why it was sent to the lab to determine whose blood it was.
And was that determination made?
It was.
Okay. And whose blood was that?
That was the front seat passenger's blood.
In terms of the location and the pattern, what does that tell you about the orientation of the front seat passenger's head at the time of the shooting?
The front seat passenger's head was actually down, almost as if he was sleeping. So it was down, leaning on the right at an angle. So his head was at an angle, as he was seated in that front seat.
And based on your analysis of this vehicle, did you find any projectiles anywhere in the headliner?
No,
Did you find any projectiles in the top portion of the B pillar on the passenger side?
no,
What about the A pillar?
no,
Was there any projectiles in the front windshield?
no.
Based on your training and experience, can you state where the exit wound of that head had to have gone through? Where that projectile would have had to have exited that vehicle?
It would have exited through the front passenger window.
How can you say that?
Number one, there's no glass there. However, most importantly is the projectile entered in the back of his skull and exited through the front of his skull with his head at a resting angle. So, can I get up?
Please, that would help and assist in showing.
So this resting angle in this seat, you have the projectile coming in, exiting through the top of the skull, and then continuing through the windshield.
You said windshield.
Or, I mean, sorry, the window.
Can you say that it was at the top of the window, or the bottom of the window, the middle of the window?
I cannot.
So based on that projectile and the blowback, you can make what opinions?
So based on the angle of this this projectile, the blowback is indicative of a firearm being in close vicinity of the head. The head is something that bleeds profusely when it's pierced. If you've ever fallen on stairs or hit your head, it bleeds like no tomorrow. And because the projectile entered in right below the skull, the blowback ended up coming in the direction of, as I was speaking earlier about the hose, in the direction that it came from. And you will get that with a very close shot. That blowback then proceeded after the shot. It went up, it hit this headliner, and continued and falling into the back seat.
Does this attempt to accurately recreate the potential location of that firearm?
So the purpose of this photograph is strictly demonstrative, to show where once the projectile enters into the head, you're going to have the blowback, which again will come up, strike the headliner, and then continue. It's actually continuing this way and landing back here behind the driver in this area of the vehicle.
In terms of the driver and the t-shirt that he was wearing, do you take into account the location of the victim's DNA on his shirt?
Well, based upon the blowback pattern up here, I would expect to find some blowback here if, on a driver, if a driver was there.
So would you expect to find the DNA of Anthony Williams on the front of the driver's shirt?
Yes.
Okay. And were you made aware that that is the results that were in this case?
Later on, yes.
And in terms of how does that help with a check and balance on your work?
So that confirms my analysis with the blowback, that the blowback came back, like I said, went up, It's going to fall here, and then it's going to continue to fall into this back seat.
So I want to move on again, and you talked about like a wound that was close. Do you look for things like stippling in photographs?
Yes, so we'll look for stippling, and it's also referred to as tattooing.
Okay. And did you notice any of that powder tattooing in the photographs of the deceased Anthony Williams?
Yes, there was some there. However, due to the fact that Anthony Williams has an intermediate object, i.e. the head back, what do that call?
Headrest.
The headrest.
Is that the word you're looking for? Okay.
Due to the headrest being there, that's an intermediate item. So the projectile was able to go into into Anthony Williams. However, whenever you fire a gun, you have gunshot residue that's going to come out of the barrel and out of the ejection port. In this case, because of the position of Mr. Williams' head and the intermediate object of the headrest assumed most of the GSR, the gunshot residue, and then only some of it went into Mr. Williams.
Without a pattern, can you give any sort of a range of distance?
No, I cannot.
Okay, so let's bring in my guest, Aaron Reed. He is a criminal defense attorney in Phoenix, Arizona. Aaron, let's talk about some of Sergeant Williams' testimony here regarding aspects of his findings inside that vehicle. I'll start with the blowback pattern. What do you make of that testimony in terms of the blowback pattern, what he observed in the vehicle, and on also the decedents, and how is that significant to the prosecution's case?
Well, first of all, thank you for having me on. The blowback and blood spatter, these are things that prosecution tends to use in these cases. When you see a close range gunshot in a tight confined space like a car, you're expecting blood to kind of fly everywhere. And when you see these patterns and you see the front right passenger, his blood on the driver and vice versa, that shows that these two may have been shot in close proximity inside of the car. So that's what they're really using it for, to try to negate the drive-by.
Okay, and a lot of this testimony, Aaron, is scientific testimony. There's math. There's a lot involved here. And sometimes for a jury, that may be a lot to grasp and digest in terms of the testimony coming before them. How do you think the expert is doing, of course, on direct examination from the prosecution, in making this understandable to the jury? And how do you think the jury is receiving the evidence?
So far, I think he's doing a pretty good job. It really does help having visual aids like that he's using, because when you just talk about these kinds of things, it gets very boring, very mundane, and breaking up the monotony of a trial with, visuals and things like that can really help. But I do think that, he's a little dry, but it's science, it's science-based testimony. It's always going to be kind of tedious, and it's just something that the prosecution has to do their best to get through and make sure that they make all their points that they need to make to confirm that this was a shooting from within the car and not outside of the car.
Yeah, what do you make about the location that this expert is giving in terms of the shooter being on the driver's side passenger seat? How is that significant in this case? And how's the prosecution going to be using that to really hit home that Melly was the shooter?
I think when you have this kind of testimony as a defense attorney, I see this as something that's one possible way of this happening. And that doesn't mean that it happened exactly the way that the expert is saying that it happened, but it is a plausible theory based on the evidence. And they have to put the shooting coming from that spot because that's where Melly was seated in the car when he left the recording studio. So they're trying to put that together to make the jury see, see, he was sitting there, he must have shot him from this angle. And I think that kind of testimony can be unbuttoned a little bit by a skillful cross-examination, which I expect to happen.
Right. Great analysis there, Aaron Reed. We're going to take a quick break here on Law and Crime. When we come back, more coverage of the YNW Melly trial. Stay tuned at Law and Crime.
Okie dokie. So, I don't know. We were supposed to be resuming court at 1:15 Eastern. So, they running a little late, which, what's new? What is new? Hold on, let me fix this real quick. Let me see. I was looking at the polls, and I told y'all, you can go back. I'm glad this is on my YouTube page. I told all of y'all, or it's on my Twitch. It's verified. I said as the days went on, we gonna watch these poll numbers slowly sway the other direction. It was firmly 78% not guilty throughout, I say, the first 7 days. Starting day 8, 9, and 10, it went to 76. I think it stayed around 76. But today, after yesterday's testimony, maybe people got caught up on it. And then what we've heard so far today, yeah. You've had a couple legal experts. We just saw a defense attorney right now saying how important that testimony was. If I'm sitting on the jury and I've tried to play the role of juror, so I can't completely say I'm going to say guilty, but I'm swayed firmly in that direction as of right now. It would take the defense finding some type of flaws either in the science or in the manner in which the science was applied that would make me change my mind. Because, again, it's a cumulative effect of all the evidence. Starting first with, it don't take a rocket scientist. They're going to bring up the DMs from his girlfriend's mom stating that she ain't got no money yet. And if she doesn't get the money, that she going to tell the prosecutors everything. Now, I don't see how everybody already forgot about that. Okay. That was obvious. If I'm in the jury box. Number 2, the contact with Frito Bang. You drop in your location at the precise time, asking to get picked up, but you didn't ask to get picked up from the hospital. You asked to get picked up off the streets. And then you fast forward to this last couple days of testimony, the medical examiners, as well as the detective right here, who's now a sergeant. Yeah, it's scientific evidence. Everybody wants DNA and gunshot residue, but here it is. We do have some scientific evidence, but you want to ignore this. But you want to ignore this.
Welcome back to Law and Crime, and we continue to follow the trial of Jamell Demons, better known as YNW Melly. While we wait for court to return from their lunch break, we are recapping the testimony from earlier today from Sergeant Christopher Williams, who is a shooting reconstruction expert and a witness for the state. So let's hear more of his testimony from earlier today.
Did you review the medical examiner's report for the backseat passenger, Christopher Thomas?
I did.
Who was it that noticed a mislabeled entrance and exit wound?
I noticed that.
And what did you do when you realized that there was an issue or concern with the report?
I notified you that there was an issue, that a a defect in Mr. Thomas was labeled twice.
Okay. And so what, after that was done, did you look through the photos from the hospital?
I did, because I observed that Mr. Thomas had a defect on his right calf area, or I'm sorry, quadricep area, the upper part of his leg. That came from the door, and it entered into the seat. And when I was looking at the autopsy photos of Mr. Thomas, I would expect to find an exit wound from the medical examiner's office, and they did not have a picture to produce that, and it wasn't annotated in their report. So again, I notified you of this discrepancy as well.
And in terms of, were you able to figure out and determine which projectile caused that specific injury based on your reconstruction?
I was.
So we talked a little bit about the shots to Anthony Williams. I'm going to move on and talk to any of the injuries to Christopher Thomas. What did you look at in review in trying to establish a shooting reconstruction of the injuries to Mr. Thomas?
So the rods from the rear of the vehicle, Mr. Thomas assumed most of his injuries from the
Jury entry. Thank you. Please be seated. Let the record reflect the presence of the defendants as counsel, Mr. State Attorney. Ladies and gentlemen, jury, all witnesses for the understand. I hope you had a nice lunch. I didn't want to off. Now to go on for the direct examination of the witness, Sergeant Williams. Counsel, ready to proceed.
So, Sergeant Williams, I want to go back and follow up on a couple of those things that we were waiting on. I'm going to start with this yellow raincoat that the blood was testified to as the blood of Anthony Williams. We were talking about that in connection with the blowback on that. Can you comment as to the location, if that would be consistent with it being in that location when the blowback from Anthony Williams' head wound occurred?
I don't think that it went back that far. Can you zoom in a little?
Sure.
And unblur it?
I'll go to the next photo on that one. Make it a little bit easier to see.
To me, that looks more like a transfer stain.
Okay.
Because it has smear in it with a drop of blood that's already dried, and so the blood is already dried and is transferred. So I think that's I believe that's a transfer stain with a hand.
Okay. So to go back to the photos that you had taken, for photo 6691 on this, what are you demonstrating in this photo?
This is a demonstrative photo that would show if an individual was seated in the rear passenger seat behind the driver, would be able to obtain a shot into the front seat passenger.
And in terms of the individuals that are in this car, how are they attired?
Mr. Williams had,
And sorry, let me clarify on that one. The people that are pictured in the photo,
oh, yes.
what do they have on to protect the scene?
They're in Tyvek.
Okay. So going on to this next photo, what are you documenting here?
It is a photo from the other side of the vehicle for its demonstrative only.
What number?
6693. I'm sorry. 6692, now moving on to 6693.
And it's just an additional angle. It's all angles from the vehicle.
And in terms of, there's a marker spot there, the red marker on the back of that individual's head in the front seat. What is that showing?
That is the approximate entry point for the defect on Anthony Williams.
And so now going into photo 6696. What angle are you showing in this particular?
This is from the rear of the vehicle.
The orange that we see at the bottom right, what are those things?
Those are the trajectory rods.
Going into the next photo, which is for council, 6697.
That's another photo from the rear of the vehicle.
Are you in any way, shape, or form stating this is the gun that was used?
I'm not stating that's the gun that was used at all.
Okay. Going into 6698. Again, what are you documenting here?
That would be a photograph of the same positioning of the gun from behind from the rear of the vehicle.
Okay. Going to photo 6701. What are you showing here?
This is showing the proximity of the back seat passenger behind the driver in relation to the front seat passenger.
Okay. And so I want to go forward to some of the ones now with the ruler. When you are putting the tape measure in, what is your purpose of introducing the tape measure in these photos? And we're now here at 6708 and 6709.
To give, for the demonstrative photograph, to give a relation of distance.
Okay. And so in terms of this picture is showing what?
Well, it's not exactly to the end of the barrel of the firearm, and so it's approximately probably about 12 inches from the head to the end of the barrel.
And so showing it from the other side, is that the better angle?
Yes.
Okay, and that is photo 6713. What are you showing in this orientation of the arm?
The photo is showing that the arm does not have to be fully extended to obtain that shot.
And so going now to this photo, which is 6714, much greater distance. Oh.
Correct. So 6714 shows the firearm in an alternative position, again for demonstrative purposes, to show a distance range, and a firearm can still be fired in that position and in the direction of the front seat passenger.
Okay. So now we're moving on to the rear passenger. Are you using the same demonstrative model for this individual?
Yes.
Okay. So you talked about the blood from Cortland, or the driver, Cortland Henry's shirt on the front. Was there also an analysis done of the blood on the back of Cortland Henry's shirt?
By the crime lab, yes.
Okay. And were you made aware of the results of the DNA of the blood sample on the back?
Objection, hearsay.
Excuse me. Watch him, son. Sustain the objection, never mind. Just sustain. Rephrase your question.
So, Detective Williams, there's testimony before this jury as to the person who contributed the blood to the back of that shirt. How does that information help your analysis in terms of the shooting inside the car?
The information was learned by me after the fact, and
Objection, hearsay.
I'm not how it helped, not what the information was.
Go ahead.
and it helped to solidify my analysis.
Okay. In terms of, based on the information that you have, can you state how the driver was positioned when the shots occurred for the back seat passenger, Mr. Thomas?
The driver, in my opinion, was seated in the front seat when the shots were fired inside the vehicle.
And in terms of how would blood get on the back of the shirt?
Because he's seated in that position.
Okay. So I want to ask, can we put some chairs here to help demonstrate what we're talking about?
Sure.
So you reviewed all of the photos from the initial Miramar crime scene,
Yes.
and is there a difference in the height of the front seats and the back seats?
There are.
And so this is not anywhere close to exact. Is that a fair statement with the chairs here?
Correct.
So, can you demonstrate, if you were the driver, how you would be positioned when the individual sitting in the rear passenger side seat is shot? If you could step down and show how would the blood from him then be on this individual?
So the driver is seated in this position, just seated here, and not moving. The blood from this individual, from the blowback, lands here, and blood from this individual lands on the back, and it's all from just not moving.
Okay. In terms of the back of the seat, is his back pressed against the back of the seat?
Yes,
Okay. And that for the first individual or the second individual?
for both.
Okay. In terms of, and you can resume your seat, we'll come back to this in a moment. So in terms of the distance between the individual in the rear driver's side seat and Mr. Thomas in that, do you know there to be a minimum distance they were separated by?
Can you restate that?
Sure. The individual, whoever was in the rear passenger seat on the driver's side, and then Chris Thomas, who is in the rear passenger seat passenger side. Is there a minimum distance that they're separated by?
There is.
And how do you know that?
So we have a known distance. As I said earlier, we are confined to the inside of this vehicle. So we have a known distance of shoulder width inside the back seat of this vehicle. We know a distance of shoulder width of Mr. Thomas, and then we would be able to deduce the difference between the center console and another passenger.
So in terms of the photos at the Jeep when it first came to the hospital, are you aware of how the back center console was positioned?
Yeah, it was down just like that.
And showing from what's been previously admitted into evidence as states 30, photo DSC_0127. Is that important for your reconstruction?
Correct. So this is the blood that is on the center console is consistent with Mr. Thomas crumpling into the position above the, or onto the center console of the back seat.
So the next photo in that series, again from States 30, is that one shows DSC 0_0133. Is this the plastic bag you spoke about and processed?
Yes.
Going back to your photos, what are you demonstrating in CSW_6716?
So this is a demonstrative photograph to show that you can fire a firearm from that position in the direction of a passenger who would be seated in that seat.
Okay. Now, looking from the other angle, what are you looking at in this photo, which for the record is 6717?
And that is just a forward picture from the front of the vehicle facing towards the back of the vehicle to show that it is still possible to fire a firearm inside the vehicle.
Okay. And then in terms of the measurement, how far away is the firearm from the face at that demonstrative photo, which is 6719?
In this particular demonstrative, it's approximately 6 inches.
Can you tell the ladies and gentlemen of the jury if Mr. Thomas was sitting straight up and didn't move to the side to get away from a gun?
At one point, I believe that he did.
And how do you know that?
Because Mr. Thomas has what's called a defensive wound on his right hand, and that defensive wound was caused by a projectile. So I believe that at some point he turned and put his hands up or attempted to de-escalate what was going on and received the firearm projectile through his thumb.
Okay, and so you're pointing to your right hand. In terms of the injuries to Mr. Thomas, do you recall which hand they are on?
I would have to look at the photograph.
Okay, we can come back to that in a moment on that. So the, and Ms. Smith is the photos. Oh, the defensive wound. Why is that important for you as a shooting reconstructionist?
Because it lets me know that Mr. Thomas was not aware of what was going on. He was taken by surprise, and his hands being up. If his hands were down, he would not receive a projectile through his thumb. His hands are in an up position, almost saying, maybe don't shoot, or I relinquish or something, but he receives a defensive wound due to that projectile, and I think at that point he repositioned to be forward facing.
Okay, and so what I'm going to do is I'm just going to approach with the ME photos, which are State 75. Showing you what's been previously admitted as State 75. Which hand is pictured as a wound in photo 12 on that exhibit?
It's the left hand.
Okay. Continuing on with regards to, we talked about, you can state that the front passenger side door, that the window was taken out by the projectile from Mr. Williams' head.
Correct.
Can you testify as to whether or not the door was open?
I cannot. I have no idea if the door was open or not.
Okay. As to the door next to Mr. Thomas, the rear passenger side door. Can you testify, give any opinion as to the state of that door when the shot to the face took place?
No.
Why not?
Well, I believe, actually, let me recant. I believe the door was closed. There is actually a projectile that goes through Thomas's door during this incident and actually enters into the driver rear door.
The driver rear door. Okay.
Correct.
So, I want to, in terms of the driver rear door, is open or closed?
I believe this door, the door that you asked about, was closed.
Okay.
Excuse me, can I just clarify what door we're talking about?
That's what I'm getting ready to do.
Christopher Thomas's door.
Okay, so we're clear here for the ladies and gentlemen of the jury. If this is the seat for Mr. Thomas, the door that was right to the right of him, we believe was closed.
Correct.
And why can you say that?
Because we have a projectile that enters in this door and travels across the vehicle and into the other door, into the back passenger, the driver passenger door.
So the door here on to the left, if you're facing forward in the car, the door to the left of Mr. Thomas.
Yes.
Okay. Can you state how that door was positioned during the drive-by, the stage drive-by?
So after Mr. Thomas was shot, the door of the backseat passenger, driver back door, was in an open position.
How can you tell that?
It was in an open position because of the projectile strike, the projectile that I spoke about earlier that enters in from the passenger side rear door, travels across the vehicle and enters into the door panel of the driver's side rear door.
Okay, so I'm going here to photo 6733 that you took. There is now another individual outside the car. What is this individual in this photo trying to demonstrate?
This is another demonstrative of an alternative theory.
Okay.
Of if a shot could be obtained from a person outside of the vehicle.
Okay, and so you mentioned we were talking about the one that goes through into the door here. Where did it strike that driver's side rear door?
It struck it where the speaker is.
Okay.
And it struck, so if you have a picture of the door, you'll see that the speaker is whole, and then it has, because it's a speaker, so it's pretty thick, and the projectile actually entered on the front of this speaker. If the door was in the closed position, the projectile should have went into the speaker.
6733, is it?
This one right here is 6733. Okay. So, and there's some other photos that we'll come back to from Miramar to discuss that one. But right here, so you're saying an alternative proposition is being demonstrated by 6733.
Yes.
Are you able to rule this out as a possibility?
Yes, because number one, the angle would not be able to be obtained into Anthony Williams. Number two, if the shot was made, the blowback would be more of a vertical blowback.
And so what do you mean by vertical?
So it wouldn't come up and down.
Okay.
So because of where we're at, as you stated earlier, of being how the seats are and the closeness, this is a little further away, so you're not going to obtain as much blowback to be able to hit up here, and the blowback would come this way, back that way.
Okay.
It wouldn't go any other way.
So I want to go So we've gone through, that was 6733. So going to I want to go back a little bit on the angle for Mr. Thomas from that alternative proposition. So we're going to go to 6722. And what are you demonstrating in this photograph?
So this is a demonstrative of an individual reaching into the vehicle to fire a weapon at Mr. Thomas.
And in terms of the shot, could the individual get that angle if from outside?
So if the individual could obtain that angle and make that shot, unfortunately they would have to be the arm would have to be completely up against the passenger. So in the photo here, the person represented with sunglasses, the arm of the shooter would have to be completely against that person to make that shot. And I don't believe that this scenario is feasible.
Okay. So, and now that was 6723. Are you showing the same thing?
Yes.
Going to 6730. What are you demonstrating with this trajectory rod and this photo?
So this is the suspected trajectory of the flight path of the projectile that went into Anthony Williams. Again, as I stated, Mr. Williams had his head canted to the right, which is the reasoning for the flight path, and its continued perforation into the window, perforated the window and exited the vehicle.
So, Sergeant Williams, I want to ask, were the driver's side window intact?
Yes.
Were you provided the keys to the car to be able to turn power on and to put them down for purposes of pictures if need be?
Yes.
So on 6732, what is, you showing the same thing as the last photo?
Correct. This is another demonstrative with the firearm canted and a downward with the ejection port facing down. And again, you would literally have to be leaning into the vehicle and onto the person who is seated in the rear passenger seat behind the driver in order to obtain that shot.
Okay. And is this the opposite angle?
That's one we already discussed.
Okay. Yes, you're right, 6733. Moving on to 6736.
What was the one just before that?
6735. And so in this instance, is this firearm, the magazine has been removed?
Correct, for safety purposes.
Okay. So going on to, again, like I was saying, 6736. What is this showing?
This is just another demonstrative of the firearm canted with the ejection port down and at an angle. Again, you would have to be pressed up against the back seat passenger that's behind the driver in order to obtain that shot.
Okay. And we'll get into in a little bit with the blue star as to why you put an individual there. So then you've gone on and showing now on 6739. What are you showing on this particular demonstrative photo?
That is a demonstrative photo showing that a firearm can be fired in the direction of Anthony Williams with the hand and with the elbow up and the the arm does not have to be fully extended in order to fire the firearm.
Okay. So in terms of the trajectories on the back of the car, I'm going to talk a little bit on that aspect. As to one that is labeled A, could you describe where that is on the vehicle?
That is in the rear hatch of the vehicle. It actually perforates the plastic. That whole back of the vehicle where it states Jeep is actually plastic, and it perforates the plastic, perforates the paneling that's on the inside of the vehicle, and it then enters into the bottom of the back seat.
Is that the projectile that you recovered?
Yes.
Okay. Going on to the other ones, we've already looked at 6760 and 6761. On 6755, are you identifying these by the same letters that the Miramar Police Department assigned them?
Yes.
Okay. In terms of the trajectories of B, C, D, E, F, G, and H, were you able to determine if there was a change in the angle of side to side on them?
Meaning a shooter's changing
Changing
direction.
lanes in a car, let's say.
So the majority of these shots was from a standing, stationary position.
And how can you tell the ladies and gentlemen of the jury that fact?
Because it's what's known as in firearms as a grouping. So it's grouped pretty close together, which means that the person's stationary, firing a firearm, and actually creating a grouping of. So if the person's moving, you won't have such a grouping, it'll be scattered.
If the vehicle was moving, would that affect it?
Yes.
In terms of the glass in the back, can you tell the ladies and gentlemen of the jury whether or not the rods that are indicated, and again the photo that we just looked at, 6753, B, C, D, E, F, G, and H at the top, I'm going to go to photo 6760, if the glass was in place when they went through?
So I would surmise that the first 2 or 3 rounds took out the glass altogether, and the rest of the rounds were not affected by the glass, and that is evidenced by the firearms unit of our lab being able to positively identify the projectiles, because the glass will make artifacts onto a projectile as the projectile passes through it, and if there's artifacts on there, our lab would not be able to identify those items.
Okay, so you said that you figured 2 or 3. Why would you give a range of 2 or 3 could have gone through the glass?
It's a rather large window. Again, it has the plastic in between it, and it's going to take quite a bit to remove it completely.
Okay. And
Now, keep in mind, this is not the way that it was when this vehicle presented itself to the hospital.
okay. And you've reviewed those photos?
Yes.
Okay. So I'm going to go through. Did you turn on power to that Jeep you mentioned?
Yes, battery pack.
Okay. And so the Bluetooth was able to be turned on?
Yes, there's a non-blurry one.
Sorry. In terms of the phones that were the most paired phones on this, what were they?
So we have 5 paired phones on this infotainment center. Number 1 just states iPhone. Number 2 states YNW 'S iPhone. 3 states the same. 4 states YNW TALABAN, and 5 states iPhone.
We talked briefly about the B-pillar column that you recovered that second projectile from. Is this a photo of that B-pillar?
Yes.
Okay. Going forward, what are we looking at in this photo, which for the record is 6773?
So this is actually the perforation site of the B-pillar, of the projectile perforating the B-pillar panel.
Okay. And then once it was removed, and that's in photo 6775 and then 6776, but staying on 6774 right now, what is this picture showing?
That would be the projectile.
Okay. And then 6775?
Is a close-up of the projectile.
So I want to go to the, and then you mentioned on the back, that was, we'd already reviewed that photo, which was 6777.
Yes.
So I want to go to the outside of the vehicle and talk about the impact strikes there. You have rods through I, J, K, L, N, O, and P. Why not M?
M is a penetrating strike mark. It actually perforates the skin of the door and then stops at the B-pillar. And because the B-pillar did the job that it's supposed to do, it's actually designed to stop around. So there cannot be a secondary spot to put a rod in to create a trajectory.
Okay. So in terms of sites I, J, K, L, N, O, and P, do you have an opinion as to how fast the muzzle of the gun was moving when those shots were fired?
I don't have an opinion. I would say that they're not even methodical. They're scattered. There's no grouping with them. It's there's no methodical reason to it. It's senseless firing into a vehicle.
Okay. And in terms of which of these I, J, K, L, N, O, or P goes through and strikes the driver's side rear door? Do you know which of those that was?
Can I look at my report?
If you need to refresh your recollection, please.
Judge, could we get the date of the report? There's several reports.
Sure. Which report are you referring to, Detective?
November 16, 2021.
Okay.
The amended?
No, 16th, the initial.
They both say that. Okay.
It would be site M. M as in Mike.
Okay. So M is the one that you could connected through to the other side?
Yes.
Okay. Detective, I'm sorry, I thought you said M stopped at the B pillar.
Yeah, I read it. Let me look.
Excuse me, thank you.
From the cold air, Judge.
It's freezing. My apologies, it's site K. K
Oh.
kilo.
K kilo. Okay. So when you are going through the rear of the car and documenting all of the strike marks, do you assign a letter to the one that you found in the B pillar?
That became site Q.
Okay. So in terms of the total number of projectiles that were fired from outside the car to the inside, how many were there? Sorry.
So we have 17.
And can you say the order of whether the ones to the back of the car happened first or the side of the car happened first on the outside?
No.
Can you say whether the shots inside the car happened first or the shots on the outside happened first?
Inside happened first.
So we talked a little bit about defensive wounds on that. Were there any defensive wounds on Anthony Williams?
No.
So there is testimony that there was a driver in a car. Could the driver, Cortland Henry, have gotten that angular shot on Anthony Williams?
No.
Why not?
He would have to have a rather large arm. Like, he'd have to be Inspector Gadget.
So in terms of, did you measure the height of Mr. Henry?
Yes.
And what was that height? If you need to refer to your
For
report, please let me know.
he's 70.5 inches tall.
Okay. And in terms of his arm length, did you measure that?
No, I did not.
No. In terms of the height to his shoulder, did you measure that?
No.
So with regards to the length of his arm, why do you say he would have to have Inspector Gadget length arm to get that shot on Anthony Williams?
Because you would have to, it would be a very awkward position that his wrist is, no human wrist is simply capable of being in order to reach around, extend it out, and pull the trigger.
Okay. In terms of the intervening objects, how does that help you in saying where that firearm had to have been?
The firearm had to have been, would be due to the headliner being there. I'm sorry, the head rest being there. That all puts it all in line with the backseat driver passenger.
Okay. In terms of the angle for the driver to get the shot on Christopher Thomas, is that possible?
No.
Why not?
Because the injury to Christopher Thomas's cheek is an exact circle. And if Cortland Henry is pointing back from the driver's seat to the direction of the position of Christopher Thomas, you would expect to see a leading edge injury to his cheek instead of a perfectly circle on his cheek.
Okay.
On top of it, you would see more blood on the seat that Cortland Henry was sitting in for both. If he were to make both shots of those two individuals, there would be a substantial amount of blood on his seat.
Okay. Now, speaking about the rear passenger, can you tell the ladies and gentlemen of the jury or identify who was in that seat?
The rear passenger,
Yes.
driver's side,
Yes.
I was advised that it was
Objection, here's
So,
the,
without going into that, in terms of what you were advised, can you say, based on your own personal knowledge, who was sitting in that seat at the time of this homicide?
that would be Mr. Demens.
Okay. And how can you say that?
objection, can we approach?
Sure.
Ooh wee. Yeah, they said we gotta approach. This is serious. Cause now they trying to put him in the back seat. And I'm not gonna lie to you, it looks bad. Because based on the trajectory and the blood splatter and the clothes that they did find on YNW Portland, it matches. He's got blood exactly how they described it would happen. And then in the back seat, I mean, none of it add up. The projectile holes in the side of the car aren't consistent with a drive-by. Like, I don't know what more. Then they even tried to tie him to being in the car because his phone was still connected to the Bluetooth. Who would have saw that coming? Wouldn't his arm be harmed reaching like that and shooting? No, what they were showing a little while ago were showing like it's not really feasible. It's not really like logical for the shooter to have been the driver. But from the back seat, you know what I'm saying, it made more sense. And plus the evidence, the trajectory, because the front passenger, I believe, was Williams. He got shot in his cheekbone from the back, from the back seat. That's the trajectory of the bullet. And the other guy got shot in his cheekbone as if somebody was right next to him in the back seat of the car. I don't know. It looked bad. It looked bad. And what they were saying about the defensive wounds, if you see a car pulling up, like, more often than not, and they start busting and you trapped in a car, yeah, you're going to try to, like, get down, but you're going to put your hands up. You're going to try to cover yourself with your hands. You're going to do something with your arms. And I guess with the amount of ammunition that was unloaded.
Ladies and gentlemen, there was an objection to the last question and answer. I sustained it. You are to disregard the last question and answer. Counsel will not repeat her question, but you are to ignore the last question and answer.
So, Sergeant Williams, can you give an area of the car with which the shots emanated from?
Yes.
And could you describe to the ladies and gentlemen of the jury what area of the car did the shots that killed Anthony Williams emanate from?
From the driver's side back seat.
As to the shot that killed Christopher Thomas, where did that shot emanate from?
Driver's side back seat.
Okay. Is it possible for there to have been two shooters inside that car?
No.
Why not?
There is no time.
So explain what that means.
So, Mr. Williams was not even aware he was about to be shot. When Mr. Williams was shot, Mr. Thomas puts up his hands and is shot, and then is shot again.
Okay.
There's no time for anybody to switch a firearm. If there were, I believe one of those individuals would be alive. There's no time to switch. It was a very, a rather rapid event of firing.
Okay. Can you say the length of time between the fatal shots and then the staged drive-by shots later on?
It was enough time for the heart to stop beating, for there to be no circulation due to the wounds that I examined from the medical examiner's office. None of the wounds have any blood in them, which tells me that they're all ante-mortem wounds. So the time was long enough for the heart to stop beating.
Okay. Is there scientific or medical testing to recreate that in any way, shape, or form?
Yes, it's knowledge. I'm sure the medical examiner could say the same thing.
So in terms of, it's nothing that can be recreated with a live human?
Correct.
In terms of the number of shots, you said 17 outside the car. How many rounds were fired inside of the car?
3.
And can you exclude the shots to the head for Mr. Williams and Mr. Thomas as coming from outside of the car?
Yes.
How can you tell the ladies and gentlemen of this jury that, for example, shot that was marked as H in the here, let's go to 6755. How can you tell the ladies and gentlemen of the jury that shot H is not the one that wound up in the face of Mr. Thomas?
Because Mr. Thomas is already crumpling at this point, and he is actually he's in the clear, if you will, of site H.
How can you tell the ladies and gentlemen of the jury that site H is not the shot to the back of the head of Anthony Williams?
Because site H continues and strikes Anthony Williams in the shoulder.
In terms of site K, the one that goes completely across the car, how can you tell that no one was sitting in the rear driver's side seat when that bullet came through the car?
It would have hit their legs.
Was there any sign of blood or anything on that seat?
There were signs of blood on the seat, yes.
Can you explain to the ladies and gentlemen of the jury what is Blue Star? You've talked about it a little bit.
Blue Star is a chemical that is used in forensics. It's very similar to what most people know as luminol.
What's the difference between the two?
Luminol is a very caustic chemical, and it's not really healthy to use. It's effective, but it's not really healthy to use. Blue Star accomplishes the same thing. It still detects blood diluted up to 100,000 times, and it's not caustic.
Oh.
So it's attracted, luminol and Blue Star, they're both attracted to the heme group of blood, primarily iron, and it will detect trace amounts of blood even after it's been washed. So if you have blood on your shirt and you throw it in the wash and throw it in the dryer and then hand it over to me, I'm going to tell you to put it back in the wash because there's blood on it still.
Okay. What if it's been 5 years?
You'll still get that result.
Okay. And what type of result are we looking for?
We're looking for blood.
And so what does it look like if there is blood?
So if there is blood, and that's the other difference between luminol and Blue Star. With luminol, the illumination of the luminescence of the blood, the heme group, is not as bright and it is not as lasting. So you have to be very quick with your photograph in order to get it. With Blue Star, it is very bright and it's lasting. So it's long enough for us to get a photograph of it multiple times. And if we need to, we can come back and squirt it again and duplicate the result if we're not happy with our photographs.
Okay. In terms of the luminol, does that destroy the DNA?
No.
Does Blue Star destroy DNA?
No.
So is there a version that the sheriff's office uses now? More so than the other? Is there a preference?
We primarily use Blue Star.
Before we end, is that something you could demonstrate here in court as to how Blue Star works?
Yes.
Do you have some with you?
Yes.
Okay. So you're going to state would be asking you to demonstrate and how the Blue Star works?
You have the show the counsel.
Counsel?
Go ahead.
No.
Need some assistance there?
Detective Williams, if you would be so kind.
So show the counsel, like,
Go ahead.
while they're doing?
No, I asked it, I didn't see you move, so I... Hold on, counsel. He wants to take a look at it.
What are we gonna do?
How Blue Star works?
So, ladies and gentlemen, I understand one of your members needs a restroom break. We'll take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence or do no research. Just leave your notepads on your chair.
Oh man, I was looking at the chat on Law and Crime. Somebody said YNW, you not winning. I said, man, these trolls is something else. These trolls, that this is all bad. I ain't gonna lie, it's been all bad since yesterday. Like, it's just been all bad. I don't even know what else to say. I mean, y'all heard it. They tried to get him to not be able to, well, they did stop him from just directly saying it was Melly in that seat. But, again, these jurors aren't, I mean, they not wearing helmets to court, okay? They not that slow. They not wearing helmets to court. I ain't gonna hold you. And maybe this is not the most important thing, obviously. But I really thought he was gonna be decked out like every day. OJ had a different suit on almost every day. I'm gonna just keep it real. He got more money than OJ. Yeah, everybody trying to read his facial expressions. Like yesterday, he was praying in court. Today, he does look. I don't know. I just know this testimony is bad. I can't wait to see how the defense is going. They should. I don't know which attorney. Which attorney you think they should use? The black guy? I still don't know his attorneys' names. That's bad. I've been watching this every day. Somebody give me their names. Yeah, he wearing the same joint. Make sure I hit that subscription button for me, please. Please, brother, please. It's crazy you gotta beg people to do stuff that's free. Like the free stuff. Like, subscribe is free. You can hit that join button and get you a membership for the low. We growing over here. We growing, okay? He looks scared though. I ain't gonna lie. I might have cut my hair before this trial, but it looked like his hairline go way far back. So if he like cut his hair, he might be in there looking so crazy to us. Nah. Man, they done convicted people of the same crime and they ain't never found no bodies. So if you can get a conviction with no body, you definitely can get one with no weapon. People keep saying that. People keep saying, oh, well, there was no shot residue. The DNA, it was no DNA on his clothes. Like, everybody wants scientific evidence, but then when they get some presented, because this is science, this is part of forensics. Blood and DNA and gunshot residue ain't the only forensics. Like, this is part of forensics. You know what I'm saying?
On crime, where we continue to follow the trial of Jamell Demons, better known as YNW Melly. A shooting reconstruction expert, Sergeant Christopher Williams, is still on the stand. Let's go back into court in Broward County. Here his testimony.
6723, are you showing the same thing?
Yes.
Going to 6730. What are you demonstrating with this trajectory rod and this photo?
Hey, look, they say his defense team is astute, like they real crafty, so you never know. We have to wait and see how they present their side, but it look bad.
Again, as I stated, Mr. Williams had his head canted to the right, which is the reasoning for the flight path and its continued perforation into the window, perforated the window and exited the vehicle.
So, Sergeant Williams, I want to ask, were the driver's side window intact?
Yes.
Were you provided the keys to the car to be able to turn power on and to put them down for the purposes of pictures if need be?
Yes.
So on 6732, what is, you showing the same thing as the last photo?
Correct. This is another demonstrative with the firearm canted and a downward with the ejection port facing down. And again, you would literally have to be leaning into the vehicle and onto the person who is seated in the rear passenger seat behind the driver in order to obtain that shot.
Okay. And is this the opposite angle?
That's one we already discussed.
Okay. Yes, you're right, 6733. Moving on to 6736.
What was the one just before that?
6735. And so in this instance, is this firearm, the magazine has been removed?
Correct, for safety purposes.
Okay. So going on to, again, like I was saying, 6736. What is this showing?
This is just another demonstrative of the firearm canted with the ejection port down and at an angle. Again, you would have to be pressed up against the back seat passenger that's behind the driver in order to obtain that shot.
Okay. And we'll get into in a little bit with the blue star as to why you put an individual there. So then you've gone on and showing now on 6739. What are you showing on this particular demonstrative photo?
That is a demonstrative photo showing that a firearm can be fired in the direction of Anthony Williams with the hand and with the elbow up and the the arm does not have to be fully extended in order to fire the firearm.
Okay. So in terms of the trajectories on the back of the car, I'm going to talk a little bit on that aspect. As to one that is labeled A, could you describe where that is on the vehicle?
That is in the rear hatch of the vehicle. It actually perforates the plastic. That whole back of the vehicle where it states Jeep is actually plastic. And it perforates the plastic, perforates the paneling that's on the inside of the vehicle, and it then enters into the bottom of the back seat.
Is that the projectile that you recovered?
Yes.
Okay. Going on to the other ones, we've already looked at 6760 and 6761. On 6755, are you identifying these by the same letters that the Miramar Police Department assigned them?
Yes.
Okay. In terms of the trajectories of B, C, D, E, F, G, and H, were you able to determine if there was a change in the angle side to side on them?
Meaning a shooter's changing
Changing lanes in a car, let's say.
So the majority of these shots was from a standing, stationary position.
And how can you tell the ladies and gentlemen of the jury that?
Because it's what's known as in firearms as a grouping. So it's grouped pretty close together, which means that the person's stationary, firing a firearm, and actually creating a grouping of. So if the person's moving, you won't have such a grouping, it'll be scattered.
If the vehicle was moving, would that affect it?
Yes.
In terms of the glass in the back, can you tell the ladies and gentlemen of the jury whether or not the rods that are indicated, and again the photo that we just looked at, 6753, B, C, D, E, F, G, and H at the top, I'm going to go to photo 6760, if the glass was in place when they went through?
So I would surmise that the first 2 or 3 rounds took out the glass altogether, and the rest of the rounds were not affected by the glass, and that is evident by the firearms unit of our lab being able to positively identify the projectiles, because the glass will make artifacts onto a projectile as the projectile passes through it, and if there's artifacts on there, our lab would not be able to identify those items.
Okay, so you said that you figured 2 or 3. Why would you give a range of 2 or 3 could have gone through the glass?
It's a rather large window. Again, it has the plastic in between it, and it's going to take quite a bit to remove it completely.
Okay. And
now, keep in mind, this is not the way that it was when this vehicle presented itself to the hospital.
Please, but they're all here, sure.
the investigator and Mr. Shea not here.
Yes.
So everybody take a look at what the demonstrative is. Any issue with that?
No, sir.
Jury ready? All right, we're all set. Let's bring the jury in. Jury entering. Thank you. Please be seated. Let the record once again reflect the presence of the defendant, Mr. Devins, his counsel, the assistant state attorneys, and the ladies and gentlemen jury are please remain on the stand. We broke. I think you're going to go over the demonstrative again, ladies and gentlemen. Remember, the witness is using a demonstrative to assist in explaining or illustrating the testimony. What the witness says is the evidence, not to be considered by you as evidence unless it's later received. So all the items of evidence go back to the jury room during your deliberations. Proceed, counsel.
Thank you. Sergeant Williams, can you explain what this object is in front of the ladies and gentlemen of the jury?
So this is the back seat of a Ford Explorer that was owned by the Broward Sheriff's Office. We were deadlining the vehicle and sending it to auction without seats. They gave me this for this demonstration.
Okay, so you talked a little bit about Blue Star. Can you explain how Blue Star is used and how it is reinstituted or reconstituted, I guess would be the proper term, for use in this?
So we use Blue Star in any crime scene to locate blood. As sometimes when we have an investigation, there'll be what is often referred to as cleanup, where the subject who committed the crime will begin to clean up the area to make it look like no crime happened.
And so when is Blue Star concrete mixed or formulated?
No, so Blue Star comes with a not normally a garbage hooker. So Blue Star comes in a container like this. It comes with a chemilucent solution, and then on top of that, it comes with 3 oxidizing tablets. All of that is contained in this box. I pour the solution into a sprayer bottle. I add 3 oxidizing tablets, and I gently stir it until the oxidizing tablets have dissolved. And once they're dissolved, it is ready to be applied. This is one of many chemicals that we use to detect blood.
And in terms of, is that one toxic?
This one is not toxic.
In terms of the time frame, once you mix it up, how long do you have to use it?
24 hours.
And when did you mix up that batch right there?
About 10 minutes ago.
And in terms of the seat that is in front of the ladies and gentlemen of the jury as is demonstrative, is it have any visible blood stains on this?
It does have some visible blood stains, and it has some non-visible blood stains.
And how do you know that those blood stains are on that seat?
Because I put them there.
And so, with your permission, Your Honor, if we could dim the lights so Sergeant Williams could step down and show the ladies and gentlemen of the jury how Blue Star works.
Yes, you may step down. Dim the lights, please. Is that good enough for you, Counsel?
Yes, Your Honor. And so, Sergeant, you're treating the entire seat.
Yes.
Why is that?
Because I don't know where the blood could be. Even though I placed it there, I don't remember exactly, so I'll spray everywhere, and then you see where it all is. You'll see that it lasts a pretty long time, and it allows us to identify where blood is.
Okay.
Everybody see that over there? Yeah.
Thank you. Okay, Travis, if you would. Sergeant, I'm going to turn the television on again. So, Sergeant, did you have the opportunity to process the 2018 Jeep Compass in this case using Blue Star?
Yes, I did.
When you are processing it for Blue Star, do you take initial photographs to show how it looks without Blue Star on it?
Yes.
And is this one of those photos CSW 4835?
Yes, it is.
Okay. And Travis, if I could bother you to dim the lights just slightly? Thank you. And again, going to the next photo that you took, which is CSW 4839.
That would be prior.
Okay.
Thank you, Ms. B. Thank you for that super chat donation. I appreciate you.
And this is CSW 4841. Again, is this prior to the application of Blue Star?
Yes.
What are we looking at here in this photo?
So this is the application of Blue Star to the picture that was just shown. And it's illuminating blood and the driver's side rear passenger seat. And it clearly shows that somebody was seated in that seat. If you look at right here, that would be where the legs are. And it continues on to show where the buttocks were. And what's very telling is that there's no blood on the back of the back seat, which means that a back was leaning against it.
Why would you expect to see blood on that area?
Because that's going to be from the blowback from Anthony Williams.
And in terms of that seat, did you saturate it like you just demonstrated in court?
Yes.
And for the record, that was 4846. This is 4847. Going out to 4848.
So this is the same back seat, the same area, it's just from a different angle.
And is that kind of the moisture that is showing up in some of the reflection in this photograph? Is that the application of the
Yes,
booster?
from the previous photographs.
So going to this particular side, what are we looking at here?
So here again you have the outline of buttocks, you have where the leg separation is, so there is somebody seated here, and then again this whole entire seat has no blood on it, where this area along here all has blood on it. So this void is indicative of an individual seated in this position.
So, in terms of the seat that we're looking at right here, remind the ladies and gentlemen of the jury which seat in the car this was.
This is the driver's side back passenger seat.
Did you also do this same testing on the front driver's side, going to photo CSW 4863 for the record?
I did.
And is this seat also processed in the same way?
Correct.
Okay. Again, showing the moisture in this photo of 4865. Was this all done on the same day?
Yes.
And 4866.
That was the smear the transfer that I was talking about earlier. So I actually swabbed that area with a swab to collect the blood, and then I swabbed an area of non-blood, an area of non-blood, and that's what was submitted to the lab.
Okay. So going forward to 4868 and 4869, and so now we're looking at 4870. What
Correct.
is that showing?
So this is the seat, and
which seat? So it's
this is the driver's seat, and the only illumination on the driver's seat is the very, very edge of the seat back on the outer portion or the interior portion of the driver's seat. And again, this is indicative of an individual seated in this seat, and that's why there's no blood here. The blood actually landed on the individual, and let me take that out for you real quick. And it landed on the individual and a little bit on the seat, right around in here, and the rest of it was absorbed by the individual that was seated in that seat.
If there's blood on clothing, would it transfer to the seat?
If it's enough blood, it can transfer. If the clothing has already absorbed it, then it generally will not transfer.
And so going forward now to the same Jeep, where are we looking at the Jeep in this picture?
This is the Broward Sheriff's Office Evidence Confiscation Warehouse for the vehicles.
Okay. So did you use Blue Star again on the door of the Jeep?
I did.
Okay, so this, for the record, we are now 4875. What are we looking at in image 4875?
This is the driver's side rear compartment area with the driver's side rear passenger door in the open position.
Okay. So going forward to the next image, which is 4876, what are we looking at here?
You see that there's a reaction to blood on the door.
And so what does that tell you as a shooting reconstructionist?
Tells me that the door was closed during the shooting incident inside the vehicle.
And again, 4877.
This is the same thing.
So, Sergeant Williams, in terms of the stippling and powder tattooing that was present on Mr. Thomas, would you give a range as to how far away a muzzle would have been from his face?
The range that I would give to that would be 8 to 12 inches.
And without the actual firearm that caused that wound, could you do a recreation?
I could not, but again, like I said earlier, this is a unique case where our shooting is confined to a known area with known confinement measurements, and it can be deduced.
Okay, so I want to go to what's been previously in evidence as states 30. On the photographs, we talked about the site K and the strike mark across the car. I wanted to go through, this is photo DSC 0403, DSC 0404, and DSC 0408. You were describing the speaker and things. Is this what you were talking about?
Correct. So if this door, the driver's side passenger door, was in a closed position during the shooting on the passenger side of the vehicle, I would expect to see this projectile strike mark to be in the speaker. So that is indicative of the door being in an open position during the shooting on the passenger side of the vehicle.
Just one moment to confer with co-counsel. And in terms of on this particular strike mark that we're looking at here on states 30, this image, was this from inside the car?
Was the round fired from inside the car?
Correct.
No, the round was fired from outside the passenger side of the vehicle. It perforated the the passenger side rear door, traveled across the vehicle, and penetrated the speaker area on the driver's side rear passenger door.
Okay. I don't have any other questions of this witness.
Counsel, thank you. Is there any cross-examination of this witness?
Just a little bit, Your Honor. Sergeant.
Or, sir, good. How are you, Mr. Howard?
Good to see you.
Good to see you.
I want to start by clarifying. You were initially asked to get involved in this investigation in November of 2021.
Correct.
More than 3 years after the actual incident, right?
Yes.
And your initial understanding was that your primary purpose, or at least one of them, was to disprove the notion that there was a drive-by shooting.
Not necessarily disprove it, just to determine if it was a drive-by shooting.
Okay. And you are aware that the person that claimed it was a drive-by shooting is Cortland Henry.
I believe so. I don't know who said that it was a drive-by. I was just asked to say if it was a drive-by.
Okay. And you are aware that when Cortland Henry made this statement, that this gentleman was nowhere around, right?
I wasn't part of the initial investigation,
okay.
So I don't know if that was included in their, Miramar's investigation with that.
Okay. But what you are saying is whoever claimed it was a drive-by shooting was lying.
Was incorrect.
Okay. Not necessarily lying, mistaken maybe?
Well, if you want to call him a liar, yeah.
I do.
Okay.
Okay. Now, you had also indicated to us, we had a little demonstration with some cheers. And I want to start off there. You had indicated that you were of the understanding that there was some blood on Cortland Henry's shirt, right?
Correct.
Cortland Henry, who you understood to be the driver.
Correct.
And there was some blood on the front of his shirt and there was some blood on the back.
Yes.
And during your testimony, you sat in what would be the driver's seat, right?
Yes.
Now tell me something. Do you know what kind of firearm was used?
No.
What caliber?
40.
40 caliber?
Yes.
If a 40 caliber is fired inside a vehicle, will it make a noise?
Yes.
Will it make a loud noise?
Yes.
Okay. And your testimony was that Cortland Henry was sitting here, sitting in his seat, right?
Yes.
Based upon your reconstruction, there was blood spatter that hit the front of his shoulder, and I think your words were, and he was sitting still and not moving, and there was also blood spatter that hit the back of his shirt.
Yes.
Okay, so with a 40 caliber blasting in that car, you're saying that based upon your analysis, Cortland Henry was sitting still and not budging. That would be your analysis, right?
Yes.
Okay. Now, you also indicated that Christopher Thomas, who you believe to have been sitting in the rear passenger seat, had a defensive wound.
Yes.
In his hands.
In one of his hands.
In his left hand. Of what that would be in feet and inches, so that we'd have a better sense.
So 4 feet, 2.5 inches.
4 feet, 2.5 inches.
Yes.
Okay. So the entire inside cabin rear of that vehicle is less than 5 feet wide.
Yes.
4 feet, 2.5 inches, almost 4 feet. Right?
Yeah.
Okay. And you were saying that there was a shot. How broad was the width of Christopher Thomas's shoulders? You indicated that as well.
It was for to the autopsy.
Yeah, sure. By the way, did you ever account for the width of Christopher Thomas's shoulders at all?
Yes, I think I got it off of the autopsy photos though.
Okay.
So, do we have them that I can review to answer your question?
That would be state 75.
Is this all of them?
That's for Mr. Thomas, and state 73 is Mr. Williams.
Do you have the one with him on the table with the scale?
That's not in evidence. So, Mr. Howard.
I don't mind you looking at it.
Is that on a thumb drive or just on your computer?
I have it on a drive here, so I'm gonna.
Got it?
Yes.
How broad?
2 feet 6. 2 feet 6 inches.
2 feet 6 inches. So that's more than half of the 40 inches.
That is
More than half of the 40.
less than half. Right?
2 feet is
24.
24.
30.
6 inches is 30.
We're at 50 and a half. So, yeah, a little over half.
A lot over half.
A little over half.
60% of the width of the vehicle.
Correct.
According to your measurement.
Right.
Okay. So that means the other person, if they were seated there, would have to be taking up less than 20 inches of space, according to you.
Right.
Okay. And in that less than 20 inches of space, you have a tape measure there?
I wish I did. I have a ruler, I think.
You have a ruler?
I think so.
Please. Thank you for having me. No? Don't have it? Okay. All right, so let's just work with our
Yes.
imagination.
Okay.
The total width of the rear of that vehicle is 50 inches.
Now that's the
Chris.
total width from the, where we measured it, which is going to be from the top. The inside, from door to door, is going to be larger. What I did was shoulder.
What are you measuring the top for? What, somebody was up on top of the vehicle?
No.
Oh, what are you talking?
Can we go back to that photo? Right, it's 4851, I think it is, or right here.
4850.
So that's shoulder right there, Mr. Howard. That's shoulder length. It's going to be larger for the seating area.
That seems to be, if I'm not, at 51 inches is the entire width of the inside cabin of that vehicle.
No, that's the shoulder. So it actually gets wider as it goes down.
What are you talking
Can we pull up a vehicle? Pull up the vehicle, just an actual picture of the vehicle.
But you're saying that's shoulder?
That's the shoulder.
Okay, well, we're talking about shoulder.
No, you're talking about butts in a seat.
No, let's...
But butts in a seat is going to be bigger than shoulder. You follow what I'm saying?
Okay. I don't, but let me just continue my question and then you can. So the width of that shoulder space is 51 inches actually, not 52. Right?
50 and a half. It's actually 50 and a half.
Okay.
The angle makes it look larger.
And that's at shoulder width.
Shoulder, yes.
And Christopher Thomas's shoulders account for 30 inches of that 51 and a half.
For the
correct?
shoulder, yes.
Okay. So the other person would have been inside of 20 inches of space on the other side.
Correct.
And firing a firearm inside that 20 inches of space minus the 8 to 12 inches between the muzzle of that gun and that face. Right?
Okay.
You agree?
I'm following along with you.
Okay.
But
Now-
can you sit back down?
I will. I'll be back. So I'll give you that he was shot in the face and not the shoulder, right?
What?
He was shot, Mr. Thomas was shot in the face and not the shoulder.
He was shot. Are we talking inside the car or?
Inside the car.
Yes.
I'm talking about the face shot.
Right.
Okay. And however, the person who was doing the shooting is now confined within 20 inches of space, according to your analysis, and the muzzle of their gun was 8 to 12 inches away. Okay? I want you first to look at...
Can we just finish your first question?
I'm about to give it to you. At 6719. Now, first of all, you said you've been in law enforcement now for 20 years. You're starting your 20th year. And a recent promotion, congrats.
Thank you, sir.
In your 20 years of law enforcement experience, have you ever seen anybody fire a firearm like that?
I have never seen anybody fire a firearm because I'm always after the fact.
Okay. Well, you go to the range.
Right. Actually, we fire like that at the range.
You do fire like that at the range?
It's called close quarter shooting.
I'm talking about that picture.
Well,
that's up there. 67.
So if this individual in the sunglasses was standing, that would be considered a close quarter shooting stance.
If they're standing, they're outside.
Same thing. Same thing. If they're seated, it's close quarter. But can we go back to your other question on the inches?
First, let's talk one at a time. Okay? We're driving
her crazy.
Crazy. Okay. Yes. All right. Now, you've indicated to this jury that in your experience, you go to the range with your fellow officers and practice shooting like what we're seeing in that picture, 6119.
6719.
6719.
Put your glasses on.
Yes, that's close quarter shooting.
Okay. And when you say close quarter shooting, you're not talking about somebody holding a firearm in front of them. You're talking about one to the direct side in the way that you have positioned those gentlemen inside that vehicle in your demonstrative shot 6719.
Can you restate that?
Okay. That image we're seeing,
right?
6719?
Yes.
You've seen people fire firearms in the position of the gentleman in the dark glasses.
That is called close quarter shooting. And like I said, I am after the fact on any shooting, but the purpose of that photograph is to show that you can fire a firearm like that.
And that you can fire a firearm like that requiring that ridiculous contortion, right?
How is that a contortion?
Okay. In any event, based upon your analysis, 6719 would be, image 6719 would be how the shooter would have to have been positioned in order to effectuate the shot that you say occurred, correct?
No. I stated that that picture is a demonstrative of showing that you can fire a firearm in close quarters just like that.
Okay. Well, you did not offer another photograph of how the shot that you claim took place from the back of that seat could have been effectuated. That's the only one that you thought to present in your reports.
Actually, you have access to all of these photos.
Correct.
And we went through with the state multiple scenarios of different ideas or ideals of how this could have occurred inside the vehicle. And this is one of them of the multiple that were demonstrated.
So you're indicating that among these pictures here on this drive, there is another?
I believe there's 3 total.
Okay. May I have the witness step down, Your Honor?
6715 is one.
Okay. 6715, isn't that just?
Oh yes, that's correct. I thought that was standing up.
Okay.
I'll come up.
That's a stay. Come on. See?
Uh-oh. Shut up!
You want to write these down?
Sure, sure. Well, actually, if you don't mind the witness testifying there, instead of me writing them down, why don't you just tap them as you go?
Okay.
That number is?
6722.
6722. Oh, this person is outside the vehicle, I see.
Correct. That's another demonstrative.
You gotta speak up, sir.
That's another demonstrative.
I thought you said the person wasn't outside the vehicle.
No, you're misunderstanding or you're taking it out of context, actually. So the pictures that I testified to were all demonstrative photos of different scenarios for the shooting.
So the person could have been outside the vehicle?
No.
Okay, but
what I testified is that somebody was inside the vehicle, but the pictures that you're referring to are you're saying that I only considered one option when I have multiple options for this.
Okay, I'm asking for you to show me the other demonstrative scenario that you presented or that you devised in your examination with the shooter inside the vehicle.
There's another one outside right there.
I noticed.
There's another one right here, 6726.
You can make it bigger so we can all
I
see.
didn't know if you wanted me to.
No, please.
It's another one outside of the vehicle.
Oh, he's outside again?
Mm-hmm.
Okay.
Outside the vehicle.
Shut up!
It's another one that we discussed during direct, where he would be up against the person seated in that seat.
And where is the shooter?
Outside of the vehicle.
Thank you.
Another one. We're only talking about Mr. Thomas?
Yes.
Okay.
Would it be fair to say that after reviewing all those photographs, the only demonstrative scenario you devised was the one that we discussed that is depicted in
6719.
6719.
67.
That's the only one.
Well, there's actually multiple pictures of 6719 at different distances, actually.
Okay, show.
They're all in here. All
Do
of
tell.
these are all different distances for
This-
6719.
The screen is yours.
So you have this one. Let me swipe it. There's two. That just shows the distance for that one. Another distance. There's another one.
Wait a second. What number is that?
6720.
In 6720, the gentleman in the dark glasses is even in a more clownish, awkward position, isn't he?
Objection, argument.
He's in a more awkward position, is he not?
He is in, actually, that's why I wanted you to sit down and finish your first question, because it would make a little more sense to finish that one to explain where you're going with this. Because where you're going with this isn't going to help if I can explain my thought process on the injuries and the distances.
You can retake the stand. Thank you. So 6720. And the other similar photographs showing the two people in that position at whatever distance the muzzle of the gun is away. The person who got shot, Mr. Thomas, sorry, the person who did the shooting would have had to miss from that distance and hit Mr. Thomas in the hand according to your scenario, correct?
Yes.
Okay.
Not miss. I think he shot him in the hand.
Oh, he deliberately shot him in the
I think
thumb.
he was firing. So this is where you're not letting me sit down there to explain this. But you got to be there too.
Okay.
I don't bite.
Let's sit down together.
I'll take that seat.
This one? Okay.
All right, so we have a little gap between us, right?
It's a big gap.
It's holds 2 drinks.
Go ahead.
I think he's having a hard time here. Speak up, please.
Okay, so I'm Thomas. You're holding a gun, right?
Oh, you've turned now.
Well, hell yeah, you're pointing a gun at me.
Okay.
So that's a defensive. Like, whoa, stop.
Okay.
So that's where we're gaining distance now.
Okay.
All right. So that's where that shot came in because what do you think? He's just going to go like that? There's no stippling here. So he's backing up. He's saying, whoa.
Right.
Okay.
And then
he gets shot. And then looks down or somehow looks at his thumb and gets shot.
Okay.
So I think that he's leaning to get away. He wants to get away. He has a gun pointed at him.
Okay. So he's leaning to get away after he gets shot in the hand, and he says, "Oh wow, I got shot. Let me look straight ahead and get shot in the side of the face."
He could be opening the door to try to get out and get shot in the face because he's doing something that's making him look forward. So he's like this, don't shoot me, gets shot, and now he's looking for an escape plan, and there's some reason he's looking forward.
That's everything you came down here to tell. Right?
Well, yeah, because he lets me do this.
Okay.
Plus you're smarter.
Thank you. All right. I'm going to move on to something else for now. You indicated I want you to take a look at 6722. This was a scenario that involved the firearm or the shooter being outside the car.
Correct.
And if you would observe in your depiction there, the person who's shooting is looking above the car and sticking his hand not quite inside the vehicle all the way, but up to maybe his elbow?
Beyond the elbow.
A tad?
Well, I don't know approximately how much, but beyond the elbow.
And you
almost to the armpit, actually.
And you opined during your direct testimony that you think it's not likely that the person could be standing outside and get that angle because his arm would have had to have been pressed up against the person in assuming there was somebody there, and you wouldn't want to be rude in a shoot.
Well, I mean, if there was somebody sitting there also and you have a gun pointed at you, I would, it's human nature to try to probably hold the person. It's, who is going to let somebody hold up against them and with a gun in their hand?
Okay.
Without taking any action whatsoever.
So part of your analysis here wasn't dealing with just trigonometry and common courtesy, that's being rude, but also your psychology of what that person would have done.
Not necessarily. So for this particular demonstrative, that is my answer. If you have somebody being rude and pointing a gun across you, I would say that you would hold it's human nature to hold it. You want to protect yourself. You would want to make sure that nobody gets hurt. But that didn't happen, and we don't have any blood directionality coming this way. So this scenario, although it was hoisted, is not possible.
I just want to be clear. The reason that's not possible is two reasons. One, the shooter would be being discourteous by pressing up against the person in the rear driver's seat, assuming somebody was there, rear driver's side seat. And two, because you are assuming that that person would have grabbed the arm and therefore it couldn't have happened that way. That is your science that makes this shot, not what happened.
And what you're forgetting to mention is the blowback that's on the headliner that would be part of this shooting incident, which I testified on direct that you would not have the blowback on the headliner if you had someone outside the car shooting Anthony Williams and shooting Christopher Thomas. So therefore you added rudeness, so I disagree. I agree it's rude to hold somebody up against their car like that. But at the end of the day, it's not possible, based on the blood evidence and the trajectories of this, that somebody was outside of this vehicle shooting into the vehicle.
At the end of the day, it's just not possible. It didn't happen that way.
Correct.
Okay. And I just need this jury to be clear on why, at the end of the day, the shooter was not outside.
Because we don't have the blood evidence and the trajectory to line up with somebody being outside of the car.
Okay. We have another picture here of, is this just another angle? We're talking about 6729. Is this just another angle of that demonstrative that we just saw?
Yes.
Okay. And in your demonstrative, the person doing the shooting isn't even bothering to take a look at his target. He's looking over the top of the vehicle. You see that?
Well, I don't think that we need to be focused on what he's looking at. We need to be focused on the position of the gun and his arm, because those are the two, well, specifically his arm, because his face is not going to fire a gun. His arm and hand is going to fire the gun. So we need to look at where that gun and hand is in order to make that determination.
Okay.
And like I said, it's all demonstrative in order to throw out, not necessarily throw out in a negative way, but to throw out possibilities or scenarios.
Okay, so if this, indulge me because we don't have anything for me to really demonstrate, but if this, for example, is the frame of the window, there's no way that the person could be like that inside and actually looking at what they're shooting? That's not possible to you.
So you're suggesting that somebody is reached fully into the car, stretching across somebody.
I didn't say anybody was in the rear passenger seat. You did. But I'm asking you,
Excuse me, guys, one at a time.
Thank you, Judge. I'm sorry. I'm asking you if it's possible that somebody could actually have been looking through that window at where they're firing instead of looking at the moonlight.
So they would, if they're putting their body into the car, they would actually have to drop their arms down in order to obtain that shot for Anthony Williams, because it is at such a degree that it exits out the front of his head and into a window, through a window. So dropping your arms in there, I just don't, it's not possible.
Okay, you do realize we're still talking about Christopher Thomas, which is the person.
Okay, I understand. I'm sorry, I'm talking over you. Yeah, sorry.
You realize we're talking about Christopher Thomas?
Yes.
Who is the person that the photograph up on screen 6729 relates to?
Right.
Okay.
So
let's deal with him before we get to Mr. Williams.
Let me answer.
Okay.
So I testified earlier that this is one shooting incident without the possibility of changing guns. So therefore, both victims are included in a simultaneous shooting incident. So you can talk about Thomas or Williams. Specifically, you're talking about Thomas and an angle that could be obtained. But keep in mind, what you're saying would have to be lined up with Williams as well, and that's why we can't agree to your theory. We have to agree to, your theory has to match the shooting incident, which is simultaneous.
Okay. I have not, thank God, been in a shooting incident myself. But I have seen on TV where somebody with a...
Speculation, counsel testified.
Rephrase your question.
If somebody with a firearm said, freeze, don't move, could it cause the people inside that vehicle to freeze and not move?
When I work the streets, I tell people to freeze and don't move, and they keep running. So I would disagree.
That's your answer to that. These people we're talking about in the scenario I'm presenting to you, sir, are seated inside a vehicle. And somebody is outside and says, freeze, don't move.
Shut up!
Do you allow for that possibility?
The possibility that, no, you don't allow for it. I'm not allowing for it, because we could sit here until we're both blue in the face and discuss possibilities. And the possibilities that you're suggesting, I don't agree with. Basically, the shooting happened from somebody inside the car. The blood evidence shows that it happened from inside the car. The angles show that it happened from inside the car. So any suggestion of it happening outside of the car I would not entertain, because it's not possible.
Except when called upon to disprove the scenario that I presented to you, you can't do it with science and trigonometry. You're telling me that the scenarios that I presented to you are impossible because of your assessment of whether or not somebody would have grabbed his arm and whether or not somebody would have taken off running. Is that what you're saying?
So the scenarios that you're presenting to me do not line up with the angles into the bodies. Those angles are set. Those angles have been completed. They don't change. The angle into Anthony Williams' head does not change. The blood spatter that comes onto the headliner and the directionality that it's going, which is it's heading towards the backseat driver passenger, does not change. So anything that you suggest would not obtain the results that are inside that car right now.
Okay, let's move on. I want you to take a look at photo 6733. We could take a restroom break if the court doesn't mind.
All right, we'll take a short recess, do not discuss the case, ladies and gentlemen. Don't form any opinion about
OMG. Hey, look, I was getting tired. That woke me all the way up. He said, if somebody has a gun and tells you to freeze, isn't that person going to freeze? That man said, I work the beat, man. I told people to freeze all the time, and they kept running. Boy, hey, look, that it was like, you know what I'm saying? Like, what? He had to sit there and take that. He sat there for a minute and just took that L. He just held on to that. Yeah, but I've been telling y'all, the medical examiner started it off yesterday. And when she testified that the person in the front seat, I can't remember which seat it was. She testified one of the victims had stippling on their cheek, which is indicative of a close encounter wound. I think the word she used again, we learned yesterday, was intermediate. Come on, man. Like, I want to be with y'all and be like, ooh, he beat that. He was innocent. They tried to railroad him. I'd be on here too. Like, civil rights is being violated. This, that, and the third. This case comes down, and look, you see the defense is now trying to distance themselves from Bortland's statement. Oh, it wasn't my defendant that said it was a drive-by. It was Bortland. Well, y'all in this together at this point. If Bortland was the driver, which the state believes he was, and the driver does not have the evidence, primarily blood, like he said, blowback and all this other type of stuff on him, and the evidence scientifically leads to the fact it came from the back seat. It was 4 people in the car. So now the defense wants you to believe that there was nobody even in the car. Well, you said it was somebody in the back seat. I didn't say it was somebody in the back seat. Yeah, hey, Jimmy, I agree with you,
We're going to go back in. More cross-examination, more of the shooting
Jimmy,
reconstructionist expert from the prosecution. This is Cross. Here we go.
That image we're seeing?
Right, bro. So now you want us to believe, oh, he took a picture to try to show y'all how it couldn't have happened. Like, it couldn't have happened like this. This is how silly it would be if it happened with somebody standing out, leaning over. Like, you trying to make that look like, oh, he thought it could have happened like this? No, he's trying to show you the opposite.
Like that.
And that you can fire a firearm like that, requiring that ridiculous contortion.
Hey, that was the other thing the defense screwed up on. It's like, I just did it right here. Look, just sit down in your chair and imagine, you got a weapon and you want to shoot the person next to you. Like, that's not that much of a stretch. I'm not even contorted that much. That's not that much of a stretch. Like, he made him look dumb on that point too.
Well,
then you got people I see in the comments on the internet saying that they've trained the same way to shoot just like that, called close quarter shooting, the same thing that this witness testified to.
The only one you thought to present in your reports.
Actually, you have access to all of these photos.
Correct.
And we went through with the state multiple scenarios of different ideas or ideals of how this could have occurred inside the vehicle. And this is one of them of the multiple that were demonstrated.
So you're indicating that among these pictures here on this drive, there is another?
I believe there's three total.
Okay. May I have the witness step down, Your Honor?
6715 is one.
Okay. 6715, isn't that just?
Oh yes, that's correct. I thought that was standing up.
Okay.
I'll come up.
That's a stay. Come on.
See? Sure.
Well, actually, if you don't mind the witness testifying there, instead of me writing them down, why don't you just tap them as you go?
Okay.
That number is?
6722.
6722. Oh, this person is outside the vehicle, I see.
Correct. That's another demonstrative.
Speak up, sir.
That's another demonstrative.
I thought you said the person wasn't outside the vehicle.
No, you're misunderstanding or you're taking it out of context, actually. So the pictures that I testified to were all demonstrative photos of different scenarios for the shooting.
So the person could have been outside the vehicle?
No.
Okay,
what
but
I testified is that somebody was inside the vehicle, but the pictures that you're referring to are you're saying that I only considered one option when I have multiple options for this.
Okay, I'm asking for you to show me the other demonstrative scenario that you presented or that you devised in your examination with the shooter inside the vehicle.
There's another one outside right there.
So I'm definitely starting to believe Philip Dubé here. The defense better have their own expert, because I don't think they're doing a great job refuting the direct examination of this expert, because very clearly he went through some of these outside the vehicle scenarios, and yet defense counsel saying, well, what do you mean? You said it couldn't happen from outside the vehicle. Well, no, he anticipated that and addressed it. Suddy, what do you think?
I think that the defense needs to have, as Philip has stated earlier, their own experts. They need to have this in play. And before he started this line of questioning, he should have actually looked at the photos so he could determine which ones would best benefit him during his questioning, and not need the witness to come from the stand to help him identify what was necessary. I think this is not a good line of questioning for him, and that he needs to have his own people.
Yeah, I think,
and
Philip,
you're
right. They probably could have cut this very short. We weren't even sure there was going to be this kind of expertise. We knew the MEs were going to be on. They were on yesterday, one for Anthony Williams, one for Christopher Thomas Jr., and that was kind of, we thought, where it might end. But at some point, this guy was needed, this reconstructionist, and I think at this point it was a good move. What do you think?
was an excellent move. If you remember yesterday, they tried to use the second doctor, I think it was Dr. Stoddard from the coroner's office, to try to conflate her expertise in forensic pathology and ballistics, you know, to try to get into some of the measurements, the projectile and the bullet pathways. And I think a jury might have a hard time accepting that type of opinion from a medical doctor. And I think that's why they had this as a backup. But I got to tell you, they need their own expert for the following reason, the defense does, and that is they want to get a jury instruction that says if the evidence is subject to two or more reasonable interpretations, one pointing toward guilt and one towards innocence, the jury is required to adopt the one pointing towards innocence. So what does that mean? The prosecution has their expert pointing toward guilt. The defense now needs an expert pointing towards innocence. Otherwise, without that conflict, the jury is stuck with accepting the prosecution's experts as true.
Yeah, that's a great point. And unless they totally discount the expert, which I don't see happening, at least based on what I've seen. So it's going to be very interesting. We do believe that this may be the last, if not one of the last witnesses for the prosecution. So we're going to get a sneak peek at the defense case very soon. Right now, though, a quick break. And we'll come back. More out of Florida. Jamell Demons on trial for the murder of two of his rap friends. We'll be right back.
Look, you see how he said friends? Like he didn't really mean it. He said for the murder of two of his rap friends? Oh, it's disrespectful out here, y'all. This was devastating. And look, law and crime ain't no joke. Soon as dude clowned the attorney when he said, I told people freeze all the time and they kept running. They put a new poll up. It went to 68%, like right off the top.
I
you talk so much. I gotta keep the road glued.
I came up with a scenario of Melly was on a horse.
Let's go, gents.
He was hired in a car.
I got one more.
Jury entering. All present? All right, let the record reflect the presence of the defendant, Mr. Demons, his counsel, the assistant state attorneys. The witness who remains on the stand, our jury is present. When we broke, you were still on your cross-examination, Mr. Howard. If you're ready, you may continue.
Yes, sir. Thank you very much. You know, I got excited. Let me get some stuff I wanted to get out the way. Okay. The firearm that you're using in all of these demonstrations is a 9mm?
Yes.
6 hour?
Yes. Oh, you're good.
Another thing, we went through the part of your testimony concerning all the potential GSR that you retrieved.
Correct.
Identified. And you swabbed and sent to the lab for testing.
Down did, yeah.
That. And you're aware that none of them came back positive definitively for GSR.
So there's 3 particles to GSR, and what was collected were 2 particle GSRs. So there's elements of GSR in there. just not all three of them. And one of them will diminish over time. Obviously, I came into it 3 years later, so the nitrates one will tend to diminish over time. The barium will be around, and the lead will be around, and that's the other two particles. So those will stick around because they're stronger metals, but the nitrates that burn, they'll disappear relatively soon, which is generally on the gunshot residue collection kit that there is. It's recommended to collect GSR within 3 hours of the shooting due to wanting to collect those nitrates so that you can have 3 particles. But just because there's not 3 doesn't mean that it's not there. What was collected were 2 particle GSR, which is 2 of the 3 particles of gunshot residue.
Okay. See if you can follow. For there to be a definitive determination that the particles that are being tested represent GSR, there needs to be all 3, correct?
Correct.
And there were not all 3 in this instance, correct?
Correct.
And the reason you think they weren't all 3 is because the third one would have dissipated over time?
Correct.
And you were called in 3 years later?
Yes.
So the incompetence that would have occurred here, it's not your fault that what you're saying is this isn't your fault.
Well, I don't know if that's a fair question. I'm not saying that I'm wrong. I collected what I saw.
Okay.
If I was there on day 1, there would be 3 particle GSR.
You're speculating that there would be 3 particle GSR, correct?
Well, it would be within the time frame.
Right. But you don't know that it would have come back as GSR because there was no definitive determination made on the particles that you collected, correct?
It's not that there is no definitive. So RJ Lee will generally want, I gave you that report. Can I have it back?
This one?
Yeah. So they have on there, I believe it says 2 particle GSR, there's over 9.
Is it correct that as regards the samples that you retrieved, the result of the testing was total particles characteristic of GSR 0?
Correct. So in order to have that, can I have that back? In order to have that, you would need to have all 3. That's my argument. So if you look at the analytical results on page 2, where it says that there's total particles characteristics is 0, and then total 2 component particles is over 9. And it explains up here what 2 components are. And the 2 components, it says right here that 2 component and
You can't read from the report.
All right. 2 component and 1 component GSR are 2 component and 1 component particles are consistent with GSR.
But there is no definitive determination that an expert would make that it is GSR without all 3 components. Is that correct?
No, so you're missing the point. There are 3 components to GSR. The report that you just referenced states that they found 2 of the 3 components of GSR. Now, it is not normal for people to have in their car lead and barium. So lead and barium are going to be in the car from a GSR incident. So those are the 2 that were collected. The nitrates were not collected because it's 3 years after the fact for me.
Okay.
So, therefore, when it says 1 component, which is going to be the lead, two component would be the other, which is barium. They are characteristics of GSR. And on that report, it states that two component particles, there are over 9. So that is everything but the nitrates. And if it was collected on day 1, you would have the nitrates. So your argument is not right.
Okay. So let's go now to 67. Oh, we're at 6729. That's the photograph with the gentleman looking at the stars. Let's go to 6730 and get a clearer picture of 6730. 6731. This is another scenario that you posited.
Correct.
And in that scenario, you have someone holding the gun sideways and sticking their hand in the window like I have my phone in my hand right now, right?
Yes.
Okay. You didn't consider somebody back here sticking the gun in a way that would be natural to shoot as opposed to what you depicted.
So if I were to consider your scenario, the projectile would actually end up in the headliner and possibly through the roof, because that is a very sharp angle. You're on your knee and you're shooting in an upward position through the window, and it would not hit anybody but the car.
Okay, I'll give you that. This chair, you would agree, that I was trying to demonstrate on is lower than the car window. You'll agree with that?
Yes.
So I wouldn't have been on my knee. I was trying to give you a demonstrative. You can
you can't tell me that.
Okay. So if somebody were sticking their gun in a natural firing motion as opposed to sidearm, at the back of that window, at an angle that would have allowed the projectile to go through that window, that's not something you considered and thought maybe you might put in the picture as opposed to this guy with the sidearm action?
Well, again, we could go back and forth onto every possible scenario that you could have in your mind. I'm not going to entertain all of your scenarios. If you come up with one that would line up with the blood and the trajectories, then we can talk about that. But as far as your scenarios that are moot, I can't speak to them because they don't make sense.
Fair enough. Have you ever in your 19 plus years seen someone fire a firearm with their hand in the position that you see depicted in your demonstrative 6731? Ever?
Well, as you said earlier, maybe in the movies.
A bad movie.
Well, I mean, whatever movie you want to pick.
In real life, have you ever seen anybody at the range or anywhere fire a firearm in the way that you depicted that person in 6731? Ever?
I don't recall, but it is a possibility that a firearm can be fired in that position without jamming and strike a target.
Okay. Now let's move to 6732. Same picture, same angle.
Yes.
Right? 6733, same sideways gun angle from the other side of the car?
No, it's the same side.
I mean, the photo being taken from the other side of the vehicle.
Correct.
Okay. 6734. The gentleman is holding the firearm again.
Same position.
Same position. 6735, same position.
Yes.
6736, same position.
Yes.
Okay. Now, of all the scenarios you could come up with to put in your report and to have demonstrated, every last one of them included somebody holding a firearm at an angle that you have never seen anybody hold it in your life.
No, that's an incorrect statement.
Okay. You were brought in to do a reconstruction, a shooting reconstruction, correct?
Yes.
And prior to doing that, you observed the shooting reconstruction that Miramar did, correct?
Yes.
And I think you said you took one look at it and you knew you had to start from scratch, right?
Yes.
The terms that you use is what Miramar did was the worst thing you had seen in your life, right?
Yes.
Okay, because they use string and some kind of gum, putty.
Putty.
And first of all, in their depictions or in their reconstructions, they had the string sagging.
Yes.
They also had all the strings from all of the perforations tied to the same lamppost, right?
Yeah, to the ruler, like a ruler thing.
The ruler?
I think it was a ruler.
Which didn't make sense at all.
No, that would surmise that the shooter stood there and made miraculous rounds.
Okay. And that, so just to be clear, what Miramar did before you took over was totally incompetent, in your professional opinion.
Improper characterization.
It lacked training.
Okay. When you said it's the worst thing you had seen in your life, your words, what you meant to say was it lacked training.
Well, it's the same thing. I mean, I don't like to be rude, but it lacks training.
Okay. So if you weren't being rude, you would say that it was an incompetent exercise and investigation.
Sustained. Let's move on. You got your point.
Okay. Thanks. And then, when you took over, the first thing you asked the state to do was tell you who, strike that. Did the state tell you who they thought the shooters were?
Question hearsay.
Excuse me, what's your side?
Did the state tell you who they thought the shooters were?
The state advised me of who the defendants were.
Okay. And they asked you what? What was the analysis they asked you to conduct with respect to the two people they had already identified?
To determine if it was a drive-by shooting or not.
That was the only purpose?
Yes.
Okay. And you asked the state to go and get you the heights of the two defendants that they had already identified, right?
Yes.
And they obliged?
Yes.
Okay. And did you take the measurements yourself?
Yes.
You have your report there?
Yes, sir.
I want you to refresh your recollection.
Objection, proper,
Stay.
Okay. You determined. Give me a second. After you did you took measurements of Cortland Henry and of Melly, Jamell Devins, right?
Yes.
And you reduced them, you memorialized them in your report, right?
Yes.
And you determined that Cortland Henry's height was 70.5 inches.
Correct.
Which would be how much in feet and inches?
5 feet 10 and a half.
5 feet 8 and a half.
So 60 inches is 5 feet. So 10 inches after that. 5, 10 and a half.
5, 10 and a half? Okay.
Am I wrong?
I don't know if that's fine. 70 inches. Let's just leave it at that.
70.5, yeah.
And you determined that his shooting height was 60 inches.
Correct.
How did you determine that?
So that was from him standing in a standing position, his arm extended out at 90 degrees, and a measurement was obtained from the ground to his finger.
Okay. Could you stand up, if you don't mind, Your Honor, and demonstrate what you determined was a shooting height?
Yes.
Uh-oh.
Okay. So stay there for a second. When you say shooting height, stay beside me. You mean hand out at 90 degrees?
No.
Okay. So when you are determining, stay up there for a second. All right. So when you say 90 degrees, you are assuming that that person was not shooting at that trajectory or that, correct?
No, not correct.
Okay, but your analysis only took that angle into account.
No.
For the standing shooting height.
So you have two different heights. Sorry, two different heights that are made into account. So the one that we just talked about, and then we have squatting with the hand out at 90.
All right.
So now we have what you just asked for, that window. Follow?
Okay. So you determined a standing shooting height of 60 inches, and you determined that by measuring the tip of Cortland Henry's arm from the ground with his arm extended at 90 degrees from his body.
Yes.
Okay, you can sit there. And then you also determined you called it a squatting shooting height of 28 inches. Right?
I keep tripping with this thing.
Off the wires. I'm sorry, let's see what we can.
Sorry about that, Jeff. See if we can anchor it. Just don't trip. Okay. And you also determined what you refer to as a squatting shooting height of 28 inches, right?
Yes.
And when you say squatting, I think the demonstration you made was doing so.
Yeah.
Right?
Yep.
Okay.
Yep.
And you determined that to be 28 inches.
Yes.
Okay. Now, for Jamell Demons, you determined him to be 4.5 inches shorter.
66 inches.
His standing shooting height was
57 inches.
And his squatting shooting height was
31 inches.
So even though he was 4 inches shorter, his squatting shooting height
I'm sorry, Ms.
was
B.
3
It's
inches
just,
higher than the taller person.
the attorney, he sound desperate right now.
Yes, so
This
torsos.
is giving me desperate vibes.
Torsos. He can have a longer torso than Henry. So you can have longer legs, but a
He
shorter
can't get
torso.
this witness to go
Or a
along with
longer
nothing
torso,
he's
but
saying.
shorter legs. So that's how that
Okay.
works to be that way.
So essentially what you're saying is that Cortland Henry has so much more of a deeper squat or a shorter torso that when he squats and extends his arm at 90 degrees, it is 3 inches lower than someone who is 4 inches shorter than him.
Correct.
Okay. Yeah.
Does that make sense?
That's what you say, right? Okay. All right. Now, what did you use these measurements in order, what did you use them for? How did you use them in your analysis?
Objection outside the scope.
Overruled.
So these measurements were used to determine a minimum and a maximum shooting distance from the vehicle.
Okay. I want you to tell me, and you were talking about the perforations that were on the outside of the vehicle.
And to the and yeah, anything from the outside of the vehicle, nothing on the inside.
Okay. So I want to use this red pointer. And let's say, for example, you had an angle like so, right?
Okay.
Into the side of the vehicle. How would you use somebody's height to determine where they were?
Objection, Your Honor, outside the scope of direct.
Oh my God!
Quick sidebar action. He's not getting this guy to play along with anything he's saying, like whatsoever. Every time the attorney says, "Would you agree that such and such and such?" He's like, "No. No, that's not what I said. No, that's not what this shows. No, it couldn't happen like that. No, no, no." I'm like, man, it just feels like he's just getting punched over and over again. I mean, that's what it's like real stuff. I told you, like, this is their best chance, because if he could discredit this witness, because this witness is actually, I believe, more important, or seems more credible and even a better witness than the medical examiner. I thought the medical examiners did relatively well.
Okay. So, let's assume this rod was at that angle. Okay? A perforation in the vehicle came from that angle.
Okay.
You would agree with me that somebody standing here and shooting could make that angle.
Yes.
and somebody taller than me standing here could make that angle as well.
Yes.
Okay. And this is not the outside of the car. This is the outside of the car, just for purposes of this demonstration.
Okay.
And somebody shorter than me could be here and make the same angle, correct?
Yes.
So, in order for you to come up with a distance for a shooter, you would have to be locked in to whatever that height is, right?
No.
No? Okay, tell me how.
So you could take, just going to refer to that worksheet that I showed you earlier.
Sure.
On other news, I'm defending Patti LaBelle in her upcoming trial. Nah, let me stop playing. Free Patti. Free Patti LaBelle. I missed it. The jury, oh, I don't know what they doing right now. Melly was a young man. Yeah, which is why I don't understand why he didn't cooperate, because he's cooperated before. Only reason I believe he didn't cooperate is because he was involved. Excuse me. That's my thinking. I'm not gonna play these little internet games with everybody else, and Like, if you didn't do it, and if it was a drive-by, you know what I mean? First of all, I don't believe that they were, like, what rappers or wannabe gang members nowadays is driving around not strapped or don't have security on them that's strapped. Like, come on, man. Like, a lot of this stuff is common. So I'm not going to play this game with the internet and simple-minded people. I'm just not going to do it. It'd have been more believable if he would have said, oh, they did a drive, because he has legal firearms. Well, you know, that's been entered into evidence that he does own legal firearms. His mother does as well. So if somebody did a drive-by and you didn't shoot back, you didn't have a weapon on you, I find that hard to believe. I find that hard to believe. I just don't think the jury, like, people are really expecting this jury to be like a bunch of 19-year-olds or something. You know what I mean? I'm not on here to play nice guy and tell people what they want to hear. I'm watching the trial. I've watched it every day. I feel like I'm, you know, competent enough to understand what's going on. And if I was a juror, unless the defense comes up with something major, which they still can, I'm still open to the thought of it's a reasonable doubt I might go not guilty. But right now, based on the scientific evidence and the fact that, you know, he hasn't made a good argument or hasn't really, you know, discredited this witness, I'm solid in how I feel right now. Now, they may come up with their own expert, and at which point, then we'll get to see how the state does in their cross-examination of the defense's expert. I mean, because you hear all these lawyers talking about, oh, well, they better put on their own experts. So if they didn't have one lined up, trust me, they about to line one up. I'm pretty sure they probably had some, you know, at least I hope. I don't know with this defense team, though. They've been losing papers and can't find this. He don't know how to work the teleprompter. Like, when the last time he did a
do this as painless as possible.
Thank you.
So, in order to get minimum, and just stick with me here, in order to obtain minimum and maximum distance for a shooter, when you have a known height, I would take, let's say for instance, the minimum height. I would take the minimum height minus the strike mark height, times that by the tangent of the angle, times pi divided by 180. Now, that being said, say I don't have a distance, or I'm sorry, a height for the shooter. And when you don't have a height for the shooter, you would somewhat reverse these numbers. I'm just going to say somewhat, just to make it easier to understand. You would somewhat reverse these numbers to where you would obtain a minimum and maximum height for a shooter. So,
but you'd have to know where the shooter was standing.
No.
Okay.
So once you have your strike mark, your entry, right? And I put the rod in there. and I get a height of the rod, I get a height of the strike mark, I get a length of the rod, and I get an angle, right? So from there, I would be able to work backwards to determine a minimum and maximum height for a shooter.
Okay.
And that I recently did with an outside agency from the sheriff's office, where they brought a car to me and wanted to know what the possible heights of the shooter are. I can only give a minimum and a maximum, and I gave them a minimum and maximum height of, and just stick with my answer here, of between 5.47 feet tall and 5.95 feet tall.
Okay.
And I said, hold on, can I just finish?
Okay.
And I said to them that it looks to me that the shooter was directly in front of this car, right at the very bumper, when he fired into, or she fired into this windshield. The detective then showed me the video, and it's exactly what happened. The shooter was directly in front of the car. So that tells me that my math was correct, and giving them and determining his distance, and then determining a height. So you have to inverse the trig in order to get the answer to your question. And that, we could be here all day doing all that math.
Okay. Let me get back to my question in this case.
Right. I thought I answered it.
Okay. Because in that other case, they had a video showing where the person was and how tall they were, but they called you in to tell them how tall they were in the video, right?
But I didn't know that they had that video.
Okay. All right. In this case, you talk about the length of the rod.
Correct.
As being part of the constant, part of the things you know.
Yes.
Okay. The length of the rod is meaningless unless the length of the rod is supposed to represent the distance from which the person is standing.
No.
Okay, so what you're telling me is that in your trigonometry, if this rod were half the distance and not as long as it were, as it is, you would get a totally different number with that same trajectory. Is that what you're saying?
With that same trajectory, can I put it in my formula here again?
I want you to answer my question.
I can't do it without doing the math. I don't know your answer right off the top of my head. That's an unfair question.
Well, let me ask you a different way. You said one of the things that you know is the angle of insertion or the trajectory into the car and the length of the rod.
Correct.
And I'm asking you that if you do your analysis with a rod that is half that length, will it change your analysis at all?
The length of the rod, keep in mind, the length of the rod is based on the terminal end of the projectile.
That's one end. The length of the rod is...
So what's sticking out from the hole, from the entry, that's what gets measured. Not the whole rod. So the whole rod going in to terminal, what's sticking out of our hole, if you will, that's the measurement when I say length of rod.
Okay. And the only significance of the length of the rod that is protruding from the hole, the only significance is if the end of that rod is supposed to tell you where the person is, Because otherwise, the length of the part protruding does nothing other than to indicate the trajectory to you.
The length of the rod has nothing to do with where the person is.
Okay, fine. So, if you have nothing but an angle, you don't have the person's height, and you don't have the distance away from which that person was, you're telling this jury that you can determine the height of the person with nothing more than a trajectory rod, and it's based on the length of the rod.
It's based on more than that.
But you do not have the variables of where they're standing, and you do not have the height of the shooter.
I can get the height of the shooter.
Okay. One of the things that you would do in your analysis if you were on this case in the exception is take measurements of the actual shell casings on the scene, right?
100%.
And you would do that in order to try and triangulate where that person may have been standing.
Correct. So the firearm is obviously going to eject, most of them eject to the right. So they'll eject to the right. It's a spontaneous distance. However, it's something of significance that would want to be documented.
Because it gives you some idea of where the person may have been standing.
It gives you an idea of, yeah, I agree with that.
Okay. And in this case, the Miramar Police Department did not take any of those measurements.
Correct.
Okay. And that handicapped your investigation, at least in some measure.
It didn't necessarily handicap it, but it could have made it for a more, it could have made it more, or just brought it more together if the measurements were there. So if I bring the car out there like I did, and I have measurements of where these shell casings are, and then I have measurements of where my shooters are, and then I can place, I can make a diagram of where my shooter is, where the casing is, where the shooter is, where the casing is. That would make for a more precise report.
Okay.
Which we measure everything. We measure all of our casings at the sheriff's office.
Okay. Now, in doing your analysis in this case, and we're talking about the analysis concerning who may have shot into the car, the universe of people that you were considering were the two people, the two defendants that the state identified for you, correct?
Correct.
Okay. So if anybody else on the planet shot into that car, that wouldn't be a consideration that you made in your analysis, correct?
The shooters that were presented to me is what I'm here to testify about. I can't speak for anybody else.
Okay, so your analysis is limited to an analysis of the two people who the state identified for you.
Correct.
Okay. And in doing that analysis, you at first determined that it was more likely that Mr. Demons shot into the car than Cortland Henry. Right?
Correct.
And then we took your deposition. Right?
Right. And then I realized that I used his actual height for the back of the vehicle.
Okay. And then you revised your report and you then concluded that it could have been either one of them.
It could have been both for the entire event on the outside of the car.
Okay. Do you think that the fact that you only came up with Mr. Demons initially was influenced by the fact that that's what the state was telling you?
No. I think that it was influenced by the fact that, as you stated earlier, with your demonstrative there with the rod, when I used his actual height, it made him taller.
Okay. So essentially, you had made a mistake because you used the wrong numbers, right?
Because for the back of the car, I used his height.
Okay. And when you revised it, you determined that it could very well have been Cortland Henry that shot into the side of that car.
It could be both, actually. So it brought Mr. Dimmon's height to where it should have been for the back of the car. For the back of the car and the side of the car, it could have been both of them.
Okay. Now, when you did your assessment of this vehicle, you said you were wearing these Smurf suits, right?
Something like that.
And it was so as not to contaminate the scene.
To contaminate the car, yes.
The crime scene, and the crime scene in this case was the car.
Correct.
The interior of the vehicle.
Yes.
And you discovered 2 projectiles that had been sitting there for 3+ years and had not been discovered.
Correct.
And you also determined that there was blood splatter on the headliner that had not previously been detected.
Blood spatter.
What did I say?
Splatter.
Spatter. Okay. Thanks. Right?
Yes.
Okay. And you know that car had been searched at least 3 times before.
I had no idea how many times it's been searched.
Okay. And do you know if they were wearing Smurf suits when they were rummaging through the car?
I have no idea. I wasn't there.
Now, the blood on Cortland, the blood on that yellow, what was it, a jacket?
I don't know quite what that was.
I want to show you
or something.
I want to show you what has been marked as State's Exhibit 31. Matter of fact, let me put it up here.
Can I look at them first, sir?
Sure. Sorry.
It just distorts something.
That's
Just to try to talk about these.
Not just a check.
Let me get a paper clip for those.
While I go up there with that, you're going to read that. Oh, can we take a break? This needs to be finished.
Sorry, you need a break?
Please.
All right, we'll be in recess. Ladies and gentlemen, just leave you know, page on the chairs. Remember the admonition, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence, and certainly no research. All right?
Well, I feel he did a little bit better. The defense, that go around, I really don't feel like he discredited him at all. He's taking a lot of stuff
The
that
jury's been excused, Councilor Mann, the defendant is dead. Is there a restroom break? No? How much more time you have, Councilor?
shouldn't be more than a half an hour max, if that much.
And how much do you have on redirect, Counsel?
I have to go through my notes, probably about 30 minutes.
So we're not going to get done tonight.
No.
All right, thank you. For recess.
You want my suggestion?
Kind of a defense theory. I think that he has a pretty good idea where he's going to go, and I think he's trying to get tidbits out of this witness. It may be that they don't really have a defense witness to counter him, and so all he's going to end up having, he knows, is the tidbits that he can get. So he's willing to take the sort of, it's sort of a bad look, some of it, and he's letting the expert kind of tell the prosecution story again on his own cross. And, Perry Mason doesn't do that. But in the real world, he may figure this is all he can get. Or he may be running around right now trying to find a defense expert to do his own reconstruction to counter this. And one thing that's very interesting, we were just talking about whether the defense theory is going to be that this was a stop-by and not a drive-by. And they're probably not committed to one story or another. If the evidence is more consistent with a stop-by, the defense may be planning to argue that the car was somehow stopped. Somebody came over looking like they were needing distress. They were asking for directions. They were doing something, some kind of diversion. And then when the victim was diverted, that's when they shot him. And that would explain why the shooting could have been close up. The blood splatter could have been from a close-on shooting. The shooting would have been outside the car, into the car, but at very close range, something you wouldn't have with a drive-by, of course,
And of course
if they were both speeding by.
That's exactly what the defense wants you to think, because if it is from inside the car, well, then that puts the finger back on Jamell Demons and, of course, Cortland Henry, not sitting at the defense table. Sonny, as we see this testimony continue to unfold, I do think he's finally making a point here or there. I'm not sure if the risk-benefit analysis pays off for him, but it may be just as David says. What if you don't have an expert? You didn't have one planned, and now you're looking at some work if you find one that's willing and able to step on board at this point.
I think my co-guest was absolutely correct, something that I had not thought about. But it does give more leeway to why the defense is taking this amount of time and asking the questions that almost seemed like he was going down a rabbit hole. However, if you turn the lens, just like my co-guest said, then, what David was correct. He's saying a stop by, as we talked about, not the drive by. All of these things would make sense. I still think he needs to wrap it up so the jury does not get lost. And if he needs to have his expert, then he just needs to put that person on. And if not, then this is the testimony that is going to be necessary.
Okay, well, let's go back into court, guys. This is, again, more cross-examination of the prosecution witness, the reconstructionist who's put all these bullets into all these trajectories and is trying to explain to this jury how they might have originated, what position, how far from any victim, how far from the vehicle. Let's go back to court.
Let's assume this rod was at that angle. Okay, a perforation in the vehicle came from that angle. Okay. You would agree with me that somebody standing here and shooting could make that angle?
Yes.
And somebody taller than me standing here could make that angle as well?
Yes.
Okay. And this is not the outside of the car. This is the outside of the car, just for purposes of this demonstration.
Okay.
And somebody shorter than me could be here and make the same angle, correct?
Yes.
So, in order for you to come up with a distance for a shooter, you would have to be locked in to whatever that height is, right?
No.
No? Okay. Tell me how.
So you could take, just going to refer to that worksheet that I showed you earlier. Sure. Mr. Howard, are you ready?
I am, sir.
I'm going to try to do this as painless as possible.
Thank you.
So, in order to get minimum, and just stick with me here, In order to obtain minimum and maximum distance for a shooter, when you have a known height, I would take, let's say for instance, the minimum height. I would take the minimum height minus the strike mark height, times that by the tangent of the angle, times pi divided by 180. Now, that being said, say I don't have a distance, or I'm sorry, a height for the shooter. And when you don't have a height for the shooter, you would somewhat reverse these numbers. I'm just going to say somewhat, just to make it easier to understand. You would somewhat reverse these numbers to where you would obtain a minimum and maximum height for a shooter. So,
but you'd have to know where the shooter was standing.
No.
Okay.
So once you have your strike mark, your entry, right? And I put the rod in there, and I get a height of the rod, I get a height of the strike mark, I get a length of the rod, and I get an angle, right? So from there, I would be able to work backwards to determine a minimum and maximum height for a shooter.
Okay.
And that I recently did with an outside agency from the sheriff's office, where they brought a car to me and wanted to know what the possible heights of the shooter are. I can only give a minimum and a maximum, and I gave them a minimum and maximum height of, and just stick with my answer here, of between 5.47 feet tall and 5.95 feet tall. Okay. And I said, hold on, can I just finish?
Okay.
And I said to them that it looks to me that the shooter was directly in front of this car, right at the very bumper, when he fired into, or she fired into this windshield. The detective then showed me the video, and it's exactly what happened. The shooter was directly in front of the car. So that tells me that my math was correct, and giving them and determining his distance, and then determining a height. So you have to inverse.
Not to worry about it. So, Howard?
Yes, sir.
I don't know where you're at with your cross, and I don't want you to break, like, exactly, because you can find a spot if you're not gonna be close to, you need more if you have now, 10 to 5, 15 to 5, so you go for a while and just find a place where it's convenient or breaking point for you. All right?
Maybe we can let it go early, and I'll just do what I'm doing now, and then we can just cut it. It'll be a little bit before 5. So, thank you.
We're supposed to tell the jury to let him go at 5 o'clock.
I love that.
All right?
I think we should go home at
4:48. I think you should tell them the temperature. They know.
They know. They're all wearing coats and winter coats.
I think here we go. I think they're gonna end for today. We had another good day though, chat. It's getting better and better, ain't it? It's picking up steam. It's getting hot in her. Thank you everybody that sent me some super chats today. You guys are the dopest.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, his counsel, the assistant state attorney, the ladies and gentlemen of the jury, our witness remains on the stand. Counsel, you can continue with your cross-examination of the sergeant.
Thank you. Sergeant, I want you to look at this exhibit. Now it no longer has the number on the back. What is this?
31?
31. State's Exhibit 31 is this yellow jacket. It's a composite exhibit, so it has multiple photographs. And it concerns, at least part of it, the yellow jacket. See that?
The yellow jacket?
Yes.
Yes.
And here is a closer view. Okay? What I want you to do first is tell me whether or not this, you can determine if that is a knit fabric or it is the fabric consistent with outerwear such as a jacket. Can you determine that from your view?
I think I might need the photo back again. I'm
Okay.
sorry. Do you want me to come to you?
Cool. Are you done? Sorry. What you say?
Yes, it looks like some type of knit fabric, but almost similar to a curtain.
A curtain?
Like very not like silk, but somewhere like a thicker fabric.
Okay, like some kind of a little. Well, let me take a. I'm not sure if polymer is the right word, but
That's a plastic.
yes.
You think it's plastic?
Okay, this is an outer raincoat.
Is it in evidence?
May I suggest using the USB? It's going to be a lot better quality than yours.
Okay, I'm being offered some assistance. And I'm going to check. Thank you.
Oh, that's much better. Oh,
Thanks. Thank you, Chris. See that?
yes. So yeah, this picture is much better. This is some type of rubbery type surface.
Right. Okay. And because it's this rubbery outer garment kind of raincoat, so you could tell that this was some kind of a smear.
Correct. So blood dries from the outside in, and in my opinion, can you keep it still 1 second there?
Yeah, I'm trying to get the full view for you.
So this is, to me, as I testified to another item, and I don't recall if it was this one, but so this is, it was to the seat. So this is what's called transfer, which is a blood-bearing object touching a non-blood-bearing object.
And in this case, the non-blood-bearing object would be the jacket.
Correct.
So the blood-bearing object resembles, let me make sure I'm still in drawing mode. Yep. A finger.
Okay.
And also another finger. Specifically, and I'm going to put it in a different color so that it can be noted. Specifically for that second one that I identified, specifically right here. That would be the curve of that finger coming in, joints, joint, joint. It looks like a finger. So it's a blood-bearing object being a hand touching a non-blood-bearing object. And the blood-bearing object had enough blood on it that it caused it to actually spill over, if you will. So all of this spilt over when it was laid down or whatever. And then, as I said earlier, blood dries from the outside in. And since it was dry, the outside was molested, and it was molested down here, and then that transfer ended up coming over to here as well. So it was touched at least 2 times by a subject with blood on their hands.
Okay. I'm going to take your word for all of that.
Okay, thank you.
But what we're looking at there, you're saying you see 2 fingerprints there?
Hold it still?
Yeah.
Okay, so let me bring up my fancy drawer here.
Wait, before I go there, strike that.
Okay. Hold on.
You see the ridges within that blood mark right up top there.
So the ridges that you see are actually the ridges of the item itself.
Okay, so I just want to make sure. So these ridges are the coat and not a fingerprint, right?
Correct.
Okay. But you're saying, notwithstanding the absence of ridges consistent with a fingerprint, you have identified by shape that whatever bloody surface transferred the blood onto this item were at least 2 fingers.
Right, so can you zoom it back out?
Sure.
And
Like so?
let's get the whole thing, bring it up a little, maybe center it. There we go.
All right.
And so what I'm saying is it resembles, it's consistent with a finger. So again, you have a finger. Whoa, how did I get so big? What did I do wrong? I got it, never mind. Okay. So you have a finger here, and you have the knuckle and a knuckle of your hand, and then you have the other finger here, right here, which these resemble fingers, knuckle, knuckle. And then again, as I stated, that blood dries from the outside in. This blood over here was all not dried yet, and then you have some molestation of this blood by an unknown object to me, and that originates actually at that crest where it's an empty spot, and it comes down this way. So, but as I stated earlier, there is enough blood on this suspected hand that when this, we'll call it a raincoat, was laid down in the back of this Jeep, that it allowed for pulling the coat to extend out, and that's a substantial amount of blood for that raincoat.
Okay. All right. So the question that I wanted to ask you is whether or not you had an opportunity. I guess I need to stick this in there.
They're charging you for this assistance.
Okay.
Big one.
Thank you so much. Now this was Cortland Henry's shirt on from which blood was retrieved, right?
Okay.
And as distinguished from the jacket, which had a material that allowed you to determine that it was a transfer smear, on a fabric that's a knit like this, you can't tell whether the blood on that is from some sort of transfer, right?
So if the shirt, first of all, it's inside out, so I can't really make a determination on it as it is. However, if you have this shirt where suspected blood is, and you spray our fancy blue star on it, the blue star will show spatter or smear or transfer.
Makes sense.
Okay.
So that if the hand that might have touched that jacket did like that, it would appear as spatter.
So the hand, if that touched the jacket, just like flicked it, is what you're saying?
Well, if in some way the hand was moving quickly and blood came off the hand onto the shirt, it would appear as spatter.
It would appear as cast off.
Okay, which is different from spatter.
It's all part of blood-stained pattern, but it would appear as cast off.
My question to you is, the blood that was retrieved, that was found on Cortland Henry's shirt, you don't know how it got there?
I posited that the blood from the front of his shirt is from Anthony Williams' blowback, and the blood on the back of his shirt is from Christopher Thomas's two rounds that he took.
I understand.
But do we have a picture of this shirt the other way around as it would be worn?
I don't know. I know you posited that it was blowback, and just to be clear, your scenario was him sitting still with a .40 caliber being shot from behind his neck, and he does not move, and it came back onto him and splattered, right?
Well, I don't blame him for moving. I mean, we have a firearm going off. I don't think I would move either.
Okay. Okay. All right. And it's not this. Where is? It's a white T-shirt. Yes. Yes.
Help with the pictures?
No. I think this is everything.
The front.
Okay. Thank you. All right.
Is there any way to rotate it, Mr. Howard? To rotate it to position.
Yeah.
Perfect. And then zoom in.
You're saying that it's not possible that that could have...
Oh, can you wait back?
I didn't do that.
It's sensitive.
You're saying that it's not possible that the blood on that shirt got there any other way than a blowback.
That is not cast off at all.
That is blood spatter from somebody being shot. That's
Correct.
the only possible way that
and
could
it's
have
actually relatively consistent with the blowback that's on the headliner as well.
Okay, so I'm just understanding that your opinion is that there's no way that that blood got onto that shirt other than blowback from a gunshot.
Correct.
Okay, and your reasoning is?
he was wearing the shirt, he was seated in that position. A gun strikes Mr. Williams, the blowback goes into the air and lands on him, lands on the headliner, lands on the back seat.
Okay. So all of the reason why you're saying that it's impossible that it got there any other way is because you're assuming that he was sitting in the seat, in the driver's seat at the time the shot was fired.
Well, I'm not assuming because it's clear in the pictures that there is no blood on that seat, and the explanation for that is because somebody is in that seat.
And it's Cortland Henry, you know that for sure.
If whoever is driving that car.
So the car was moving at the time these shots were being taken?
Whoever was driving it, whoever was seated in that seat.
Whoever was seated in that seat.
Correct.
Okay.
But that's cast. Can I look at the back one?
Okay. That's actually the front.
That's the sweatshirt. This is the t-shirt he's asking to see.
He wants to see the back.
That's the back.
Okay.
The back is the large logo.
Okay.
Okay.
It's the back.
Yeah, that's not going to be.
I didn't do that. It's
I
on the
think you
back,
did.
so.
That's not transferred either.
Okay, that's definitely coming from blowback.
Yes.
Okay. And your the reason that you are saying that is?
It's shape. It's consistent with, and it's coming down. It's coming from a up and down onto the shirt, and it can try not to touch it.
I'm not touching.
So, all right, I'll use white. So this is actually what the hell? White. So this is actually coming down, and this is coming down also. So this is coming from above. I'm sorry, I'm losing the microphone. This is blood coming from above the shirt. So that's not going to be transferred.
Okay.
So this is blood that's in the air and coming down onto the shirt. And that's what I'm reading in these photographs for the back of the shirt as well.
Okay, you done with that?
Yes, sir.
And the only way that blood can come from up down onto a shirt is if it's coming out of a wound when a bullet hits the person.
Correct.
That's
So it's going to be coming, and it's not necessarily that it's going to be. It's if you shoot somebody in the arm, it's not necessarily going to cause as much blowback as the head. So the head is the one that's creating the majority of this blowback.
Okay. Now would be a good time, Judge.
All right, ladies and gentlemen, we're going to pick it up tomorrow, so remember the admonition, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence, and certainly no research. Just leave your notepads on your chairs, we'll see everybody back tomorrow at 9. Thank you, ladies and gentlemen. Have a good night.
Ooh, we went long today, y'all. You know what I'm saying? Yeah, they went in today. So when this is done, I'm going to just wrap it up. We'll catch the recap analysis on what the experts think about in the morning. Again, thank you guys for the super chats and all the love. The conversation, the insight. I just feel like today...
And the assistant attorney, anything to discuss, guys?
Just one thing, Today, this afternoon, the defense counsel filed a notice of deposition for this Friday without consulting with myself or Ms. Smith at all as to our availability. I am not available for a deposition on Friday as I have other hearings and things that have been set at the time that's selected. So I was going to ask if Your Honor would be so kind as to intervene and perhaps tomorrow have it set for tomorrow afternoon and to vote about on the depot tomorrow afternoon, because I think we will finish with Sergeant Williams, and then there's one other records custodian for the morning that's a quick witness, and then we could use that afternoon to take the deposition.
Are you going to produce involved in it? Is that wrong with that?
Are you going to produce him?
I have been trying to serve the witness. He has failed to appear. So in terms of
The only reason I did that, Your Honor, and it's my fault, is we just recently got a new address on this witness. It is Trevelyan.
Look, I can't read until they
That was one of the witnesses that I had filed a motion for better address. We got a better address. We tried to serve him at various addresses. I filed numerous motions to exclude him. Judge Siegel would not grant that and basically said if the state produces him, we'll recess and take his deposition. As soon as I got that new address, we took the depot. They want to produce them tomorrow afternoon.
So you don't have a subpoena?
Oh, yes, we do. We did. We served
He
a
was served
person
last
at that
night.
house.
His mother was served. His mother was served at 5 o'clock last night.
So we scheduled it for Friday because we know we're off on that day. And we need time to transcribe that witness if the state is going to call him as a witness, and we didn't want any delay. If they want to produce him tomorrow and the court wants to recess early, I'll do whatever they want.
So Judge, my concern is that defense counsel said this unilaterally, and I've been here next to the court for the last 2 days. They obviously went about or taking steps to do this, have this way to serve, but took no step to coordinate with the state. They have to do that. I cannot produce this witness. I cannot have service on him to get him to show up for a deposition on that. So I would just ask Your Honor.
Can I stop you for a second? Do you have service on him for the trial?
We've made several attempts, and in fact, Your Honor, I spoke with him myself. He indicated to me that he was not coming, and I asked him if I could arrange transportation, arrange a hotel. He said if I sent a plane for him, he would not show up. Those were his comments.
Well, and so then to follow up as to the next statement that he made to Ms. Smith, would it be so kind?
Yes, Your Honor. He did in fact tell me that he felt concerned for his safety, and the state
This is
requested
good.
him to be here in Broward County was a risk to his life, and that the state had no concern for his safety, and he refuses to come here out of fear.
So
He refused to say who, Judge. I did ask him if he was threatened or requested not to appear by anyone, not insinuating from any specific person. He said, "What do you think?" And I said, "I can't speculate," and he refused to further comment.
But you have service on him.
We have a subpoena served, I think, on his mother, accepted service for Friday at 10:30.
And I'm waiting for the affidavit, or I would file it.
And yes, ma'am.
I'm not available. I'm before Judge Siegel on a hearing on a different case on Friday morning.
What case?
Calvin Smith, that is a 2007 triple homicide that he has been in and out of the hospital. It's with regards to his placement, and if he's hit his mark of 5 years for continued incompetence or he's going to remain.
And how long is your hearing supposed to stay?
It is scheduled for an hour from, let me double check on this, it might be scheduled. It's scheduled from 11 to 12. On that, they set the deposition without any notice of attempt to coordinate with myself for 10:30.
Understood, and I understand they're supposed to try to coordinate with you, but regardless of that, because of the circumstances of this case, or you suggest, it's all speculation, but if Ms. Smith indicated that he indicated he wasn't going to cooperate in any way, shape, or form, the chances of him showing up for this deposition are slim to none.
Agreed. My concern though is that this is the second deposition we've had the discussion, because then the next thing I have to bring up with Your Honor is we're going to have to coordinate an additional deposition because defense had deleted a witness from the witness list in March of 2022, and then now they just told me today that they are going to add that witness back on. So if I cancel the previously set deposition of this witness, and so now they're putting this on again last minute in terms of that. So we're going to have court intervention as well as to that scheduling and making sure everybody's available for that.
May I respond to that, Judge? She provided case law last week, I think last Friday, which now requires us to put that witness back on.
And we agreed to produce him next week.
Whatever she wants.
What
it will
at
be
their
them.
command.
Who's the witness?
It would be our cell tower expert or cell phone.
So, pick a date next week and do it. What's the?
Yeah, coordinate.
She told her whatever day she wants.
So we made attempts to coordinate, and they failed to make attempts to
We'll
coordinate.
coordinate.
We're just asking for the same courtesy.
No, we
This
will not
morning,
the same
I
thing.
said, give me a date.
And
All right,
so,
that's a non-issue. Next week, they've agreed they'll produce this cell tower expert. All right. So let's go back to the witness, I forget his name.
Carry on glass.
So assuming, Mrs. Smith, are you available on that date?
Not at certain times, but I also have been scheduling all my
No,
other
I
cases.
understand.
Yeah, I have Judge Fine in the morning, and I have a deposition at the jail at 1 p.m.
All right, so I don't know, how long is this deposition supposed to take if he shows?
It's set for 10:30. I would imagine that we would finish certainly by, well, if he doesn't show, we'll be out the door at 11. If he does show, I anticipate the depot would take somewhere between 1 and 2 hours.
and so, Your Honor, I also have other hearings that morning starting at 8:30. I am before Your Honor on the co-defendant on this case. I have 3 other hearings from Judge Davis, Judge Fine, and Judge Zia.
They're not going to work with you on either rescheduling, I mean, somebody standing like for Mr. Henry's case. I mean, that's just the status.
No, there's been a motion set filed by defense.
I saw it.
So,
I can reschedule. It's not an issue. We talk to the defense and your trial. You're trying to pick a jury. I mean, I don't pick a jury, but take a deposition of a witness. That, to me, that takes priority.
of course, Your Honor, I agree, but my just concern is that there's no professional courtesy from defense to the state.
I agree with
So can
you.
we just move
I
it to
agree.
the afternoon? I'm available
They
later
don't
that
have,
afternoon if
they
we
don't
do it
have
at.
service on the witness in the afternoon. They have service on the witness in the morning. Where's the deposition supposed to be taken at?
It's a Zoom deposition?
Well, we changed it to a state attorney.
At the state attorney's office?
Yes.
Yeah, he's.
To make it easy.
And this is a witness that is not local and doesn't live here? So is the deposition been served via Zoom or is it via personal service through a neighboring travel? Because this would be a witness that resides outside of the jurisdictional bounds of Broward County, and as such, we would be required to travel to his location to take the depot per the rules of criminal procedure.
This is a lot of information here. You got service on him through his mother, but it's not his residence?
Whatever the address they gave us, and they just gave it to us last week, we immediately attempted, and we knew we needed, we figured we would take the depot on Friday so that we would have time to transcribe it and not cause any delay. Because we're under the impression, and Your Honor did not grant the motion to exclude these witnesses that we've attempted to take depots, attempted to serve them in numerous places over the last 2 years. They are listed as A witnesses. I suggest to the court that they are material witnesses if they show. And we're doing everything we can under the circumstances not to delay this one. I mean, I don't know what else to say.
I understand what you said. I heard you. So this is my thought. I don't know who you have hearings with tomorrow. You mentioned Judge Fine, you mentioned Judge Siegel. I don't know what Judge Fine's schedule is or not. I don't know what Judge Siegel's schedule is or not, but I'm sure that is something that we can work out. I know as to the case you have with me, I'm sure it's something we can work out. So,
Of course, sir. But again, I'm just being told now that I'm supposed to now provide a room.
I agree with you about you should have been noticed. I don't have any issue with it.
I take full responsibility and I apologize.
But the question is, what are we going to do now?
Well, if it's on Zoom, that's a lot easier, because then I can jump on and go from there. But for defense counsel to then all of a sudden make this here in person without any notice to the state seems highly irregular on that. So, this is still going to be on Zoom, the witness can show up and then be told, we moved it to this afternoon when everybody is available, and do it at 3 p.m. after Ms. Smith and I are available to take this witness's deposition.
So is it on Zoom?
We served him on Zoom, for Zoom, and we changed it because of how material he is.
So it's not on Zoom, it's supposed to be scheduled in person?
Yes, sir.
We'd be fine with striking the witness if the state
I mean,
wants.
exactly. If they say they talked to him and he's not coming, just remove him from the witness list, for God's sakes. I mean, we've been trying to take his depo for 3 years, Judge.
So we'd be happy to go forward and forfeiture by wrongdoing because the feels threatened and can't be here in court.
All right, so this is the way we're going to handle it. All right, the guy's noticed to be deposed. Now it's not a Zoom deposition; it's in person. It's inconvenient. It should have been noticed to you. I agree with all that. But we're in trial on a serious case. State seeking the death penalty. I mean, sometimes we have to change. They were able to get service on the witness. Let's see if he shows up. So if you need assistance with any of the judges, I'll take care of it. You let me know who it is. I'll either reschedule those hearings. I'll ask my office to do that. And we'll contact the judges. Just tell them that you're incapacitated because you're taking a deposition.
Not a problem. And just so I want to make sure that travel has been arranged for this witness, if we're doing it in person.
It's a 2-hour drive. I don't understand why you arrange to travel.
Pardon me?
It's a 2-hour drive, I believe, from his house to here.
I don't know any of that. To be candid with you, I don't typically arrange for travel or have it, but whatever the rules provide for, that's what the rules do.
If there's any travel expense, if he shows, we'll reimburse him.
All right, so let's just see what happens. My guess is if Ms. Smith's conversation is correct, he's not going to be here anyway. So let's just see what happens. All right?
May I suggest that the state attempt to call him tonight or tomorrow and see if he's going to show?
Or strike him.
Or in the alternative, strike him. I mean, Judge, we've tried like numerous times to get these witnesses.
For years.
I mean, we're in the middle of the trial.
Judge, may I just say that there has been this ongoing problem with respect to these witnesses. This particular witness now, we're being provided an address and simultaneously being represented by the state. He's not going to show. So we should probably stop with the charade regarding this particular witness and just strike it. If they're saying he's not going to be available, I don't know why we'd be jumping through hoops to waste our time. Just strike him from your list and we can all move forward.
Well, there's other remedies available to the court or the state.
So I'm not going to go around in circles, all right? So if the witness shows up for deposition, he shows up for deposition, and if he's going to testify, he'll testify, and we'll see what he says on Friday, is it? All right, so you just make yourself available for that. If you need the court to contact other judges to let them know what's going on, I will.
Thank you, Your Honor.
All right, so just leave it as is, and when are you going to let that council know the date you're taking cell tower experts?
And looking in terms of scheduling and whatnot on that, we can do it on.
Exactly.
I'm gonna have to do a couple of scheduled juggling on that because I just found that out. So I have other outside issues that I have to deal with.
Can I ask you to just to have a decision by, let's say, noon tomorrow as to when the witnesses to appear?
Of course, Your Honor.
Does that work for you, counsel?
Yes, Judge.
And this is not the witness that's in Hawaii?
No, he will be here. That was the other thing, because we were expected to start the defense on the 10th. Are we still on track to start our case on the 10th?
State's not resting tomorrow, Your Honor.
All right, so assuming that when this witness, his testimony is completed, who do you have next?
I have some record custodians, and then I have lots and lots of videos and photos to publish for the jury that have already been admitted.
And when do you anticipate doing that?
Tomorrow afternoon, and then we'll have other witnesses that aren't available until the 10th of July.
What other witnesses?
The lead detective for one.
So, when and how long do you anticipate the lead detective, that's Moretti, Detective Moretti, is that right?
40 some odd search warrants that were written and issued and signed on this case.
Just give me an idea of the time, estimate. I'm not trying to hold you to it.
At least a day on direct, maybe longer. I couldn't.
So you say he's on for at most 2 days?
Maybe 3. I wouldn't say, just in terms of there's an hour and some long video to watch with him as well.
So it's not going to be on the 10th? Is he available next week? You want to do this? I mean, I know I told the jury, or I think your thing said we're out next week, but so that's no good. But the following week on the 10th.
And
so if you go to the 10th, I'm sorry, 10th, 11th.
Can we approach on scheduling? So.
Something we're about to avoid. Right now. All right, I don't know what you've arranged or not arranged for what's good for the goose is sauce for the gander, they say.
I think that's a good, correct statement.
So you can work it out.
Yes, sir.
And if you need assistance with other judges on scheduling for the deposition that was set by defense without courtesy of letting you know up front, you let me know, I'll assist you with that deposition. Should go forward.
Understood, Your Honor. Can we have an order, though, from Your Honor, that no other depositions will be scheduled without coordination with both parties?
And hopefully that coordinate. I don't need an order to do that. It's the rules of current procedure. And it's in there. You do the best you can, all right?
Yes, sir.
Have a good day.
Have a good day, Judge.
Thank you all. Appreciate it. We're adjourned.
Stewart?
All right, y'all. That's officially the conclusion of today's testimony and court proceedings. As y'all know, this saying, my phone ringing. One love or no love. And if nobody told you they love you today, I love you. And I'll see y'all next time. Yada, I mean.